This is the case of the state of Ohio versus Vanessa Brown, case number 23 CR 40163. Present before the court is Ms. Brown, right?
Yes, Judge.
Represented by Mr. Washington, we have Mr. Harris in the prosecutor's office and Officer Evans filling in from probation. We're here today for a preliminary violation because I've received a report that alleges that Ms. Brown has violated the terms of her supervision. It's my understanding that we are waiving probable cause for the purposes of today's hearing, and we're going to set this for a final. Is that accurate?
That's accurate, Judge. I would like to address her conditions of a potential bond.
Okay. So, Ms. Brown, we break a probation violation into three parts. First is, what are you accused of? Secondly is, what are we going to do in the meantime? And the third thing is, if you're guilty of these violations, what are we going to do about it? So essentially what we're doing is we're short-circuiting the first part, which is we're going to set it for another hearing. And then today's purpose is to discuss what we're going to do between now and the time then that we figure out how all this is going to go. I understand there is a charge in Mason that is going to be bound over. So we may be getting a new felony case through the grand jury. What do I need to know about this, Mr. Washington?
It hasn't happened yet. And not to mention, you said that you got a conviction in Butler County, you got the case in Fairfield, you got the cases in Cincinnati. He knows all this. He's one. He did a deep dive. Judge, yes, we'll waive the probable cause at this time.
All right. What do I need to know on the issue of bail?
With regard to bail, Judge, Vanessa, obviously there's some issues that we have to get adjusted. My understanding is that there's potentially the case in Mason potentially may resolve itself after talking to her. We recognize that she does have cases in other jurisdictions, as the court indicated when we were in chambers. She is having significant medical issues. She's had multiple surgeries over the last several months. The thing about it that's been a little odd is that she has been on the EMU through Butler County for the last, I would say, 6 months, where she's, even when she was hospitalized, she still had her EMU unit on. She reported when she was supposed to. We just did resolve a case for her in Butler County on Tuesday, where she received a period of probation from Judge Hiley. And also the Mason case, we did get an OR bond because she has some medical procedures that are scheduled for next week. So I'd ask the court to consider, I know that there are several cases that are pending, but with regard to her health conditions, I'd ask that the court allow her to be released on the EMU so she can resolve those prior to us coming back and potentially getting her probation violations resolved.
Sheriff, state opposition to any of that?
Your Honor, it's my understanding that the court has some history with the defendant, that she had been admonished not to go out and commit other crimes. That obviously wasn't the case, and I don't know if her medical conditions, as the timing, has prevented her from going out in the community and reoffending. So, state's concerned, we would object to any bond at this time. Any change in that?
Also, Evans, state opposition?
I also believe Officer Fisher stated that the defendant has 2 active warrants right now as well.
Ms. Brown, anything you want to tell me on the limited issue of whether or not I should let you out of jail?
I have minor children that I'm caring for and I do have a surgery scheduled. With the box, I just want to get my household taken care of. And I turned myself in. I actually retained counsel, turned myself in when I found out about these different things that, were going on. I promise I'm going to come to court. I just wanted to situate my children, and they're starting school. They're at home by themselves. And I also want to get my hernia repaired. I'm going to come to court. I was in contact with Ms. Fisher. I called my probation. I come to court like I have not just disappeared and never came to court with the issues and things that's going on.
Yeah, Ms. Brown, I'm not going to release you from jail. I think we were pretty clear when I was here the last time. I told you that if you committed a new criminal offense that you were going to be incarcerated for an extended period of time. That appears to be the way this is going to play out, so I am not going to release you from jail pending the disposition of this case. So, Mr. Washington, you can talk to Ms. Brown and let us know when you want it set. If you want it set in a couple of weeks, we'll set it in a couple of weeks. If you want it set in a couple of months, we'll set it in a couple of months. Doesn't matter to me. It probably depends on how the Mason thing goes.
Right. I think that, say it again.
Make it move fast.
Fast. You want, okay, but then, because I told you, his intention is to send you to prison.
For a couple months. I'm not sitting in jail.
You want to sit to Warren County Jail for a couple months? You want to come back, get sentenced, and then what you'll have to do is when you're in prison, you're going to have to file fast and speedy prosecution motions. So they'll either have to drop them or bring you back for it. So
Couple months.
you stay at Warren County Jail for a couple of months if we do that?
Yeah.
Yes?
Yes.
Okay. Judge, we'll just, are we going to schedule now or should I go to the side?
Ms. Crook will get your hearing date after. What do we want, a couple of weeks?
I'd like, can we do a couple months?
Doesn't matter to me.
Okay.
What's our jail days as of today?
8.
8? All right, we'll see you in about 60 days.
Okay. Thank you, Judge.
All right, that's all.
Thank you, Your Honor.
Out of the house.
Are you in a moving car?
No, I'm parked at a school and they're playing at the playground because I know that they're not going to be quiet and let me do this in the house
All right.
the last week of summer. I have some crazy kids.
Good morning, Mr. Thornton.
Good morning.
Mr. Butchart, could you join us, please?
Good morning, Your Honor.
Good morning. We're going to skip ahead for just a minute. Tracy Hicks, would you join us, please?
Yes, sir.
In file number 251492, Walnut Meadows Apartments versus Tracy Hicks, the complex, through their lawyer, has dismissed this case without prejudice. Which means you either paid or moved. But you're free to go.
All right, thank you.
All right. Thank you, Mr. Thornton, for that. All right, let's get back to our 8:09 o'clock case. Village Manor versus Felicia Otel. She's parked here by telephone. Attorney Brian Butchart is here on behalf of the plaintiff, and their manager, Lisa Cousineau, is also present. This is filed as a demand for non-payment of rent. I've gone through these once with our next defendant, Tara Winters, but this Otel has not heard them. You are a defendant in a landlord-tenant case, and this one is non-payment of rent. As such, you have certain legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If you wish to have a jury trial, you must tell the court at this first appearance or file a written demand within 5 days and be prepared to pay the $50 jury demand fee. Normally, our legal aid representative is here with us. She may be tied up in another court. I'm not sure. She isn't here yet. if the action is for non-payment of rent, you may be eligible for some emergency financial assistance, in which case you could ask the Michigan Department of Health and Human Services, Neighborhoods, Inc., or Community Action Agency for some emergency assistance, or if you're a veteran, you may be eligible for some assistance. But frankly, none of those agencies right now have very much money. There's more demand than there is a resource.
Yeah, I've checked
Yes.
with all of those places. Sorry, sir.
All right, we'll get to that in a minute. You may be able to reach an agreement by going through mediation. If both parties are interested, the court can help set that up. And if the matter can be resolved with a settlement agreement, it could be resulting in what's called the filing of a conditional order of dismissal. Rent here is $285 per month. The arrearage was about $1,500 at the time of filing. Mr. Butchart, what's the current status?
Your Honor, according to my client's records, they're showing rent to retain possession in the amount of $1,692. We have court costs in the amount of $200.50. So the total claim today, Judge, is $1,892.50.
That's through August.
That's correct.
Ms. Otel, your rent is not very much per month, $285, but you've gotten signed in several months. Now, you indicated you have requested financial assistance.
Yeah, I've been calling. I called Salvation Army, Keystone, United Way, all of those places. Like you said, nobody has any funds. I have a list of churches that I was going to start calling. I actually already started calling, and I'm waiting on some callbacks.
Have you contacted DHS?
Yes, I'm waiting I got a hold of them as well. And I'm waiting to hear back. But I also made 2 payments just recently to my landlord. What it was is I am disabled, single mom, and when my child support is stopped or there's holidays, I get behind. So what I'm trying to do is my other father of my youngest just started making payments, and that's been helping me be able to make more payments towards my rent. But I've also had a lot of health problems.
Several months behind. Now, the law requires that I adjourn this matter at least 7 days. And that would be until next Friday, August 22nd. I won't be here next Friday. So we're looking forward to Monday, the 25th, which would be 10 days. Mr. Butchart, are you available on Monday, August 25th?
Your Honor, we can certainly make sure that someone from our office is, if not me.
All right, let's continue to 8/25. 25 at 2:10 p.m. Ms. Otel, we're going to continue the matter until 10 days from now, and we'll see how you've done with requests for financial aid. If they get what they ask for, you would get 10 days from August 25th to move or be subject to being evicted, which would bump this into September, and then another month's rent would be due in September. So my advice to every client is stay in contact with your manager, Lori, and let her know.
Yeah, I've been in contact with her.
All right. We're going to revisit this, but this is, the wolves are at the door here. Unless the rent is paid, you're subject to being evicted, and you're not going to find another tenancy at $285 a month. And if you're evicted from subsidized housing, it could make it very difficult to get into it again. So let's hope somebody can give you some money and help you get caught up on your rent.
Okay.
All right. Now, you said you've made some payments. Should you get some credit on this, or you made payments and then this is still the...
I think they already credited it. I believe they already credited it. I made a $400 payment at the end of last month, and then I just gave her another $250 yesterday. What was at the beginning of the month, I only got a $6 check, and then I only got an $8 check, and then I got a $30 check. So
Well, if the
I don't have
250
contact. Yeah.
hasn't been credited, it will be.
Okay.
It-
Yeah, I
All
just
right.
gave that to her yesterday, and then I talked to Mary at the front of the office, but I didn't get to talk to Lori.
Yeah, Judge, and just
All
so,
right.
so the court's clear, I think we do have the credit for the 400, but the $250 does not appear on the ledger that I have. So since it was just paid
Okay,
yesterday.
yeah, I just said that.
All right, so in which case that would reduce the amount by 250, which would make it about $1,600. All right, we'll visit this in 10 days, August 25th at 2:10. Ms. Otel, if you can't log in, I'd prefer you either be here or at least connect by Zoom. I prefer not to
Okay.
do telephone, but all
Okay,
right.
I apologize about that. It's crazy.
Well,
with
we
the kids
managed
still
to do
home.
what we needed to do, but all right.
I apologize.
All right, thank you. Hope you can get some money.
Thank you, Your Honor.
All right, thank you, Lori. I'll see you next time.
Thank you.
All right, Mr. Lance Thornton is with us on our next set of cases. Also, Megan Bauer has joined us from Legal Aid. She's always welcome presence. All right, our next one is Walnut Meadows versus Tara Winters. Miss Winters was here early, and I went through the advice of rights. In fact, she is so lucky she got to hear it twice. Mr. Thornton is here, and Judy, the manager at Walnut Meadows, is here. Let me make some notes. This is also a demand for non-payment of rent case. Mr. Thornton provides me with these very helpful judgment informations. He and several others locally do, and it makes my life easier. Ms. Winters, they contend that you owe June partial, July a late fee, August and a late fee of $2,182. Utilities, which are water charges of $65 a month. Three Rivers has significant water charges. And that's $130, and court costs of $184.33 for a total of $2,496.63. Is that still accurate, Mr. Thornton?
It is to my knowledge, Your Honor.
Judy, you concur?
Yes.
All right. Ms. Winters, what's your position here?
I got behind because I had got hurt at work, and so I was off for a little bit, but I'm back to work, and I've been working a lot of overtime to get everything caught back up. So I just am really trying. I've called some legal aid places that Judy actually gave me to call. The guy's supposed to call me back on Monday. So I'm hoping to hear back from him and be able to get a little bit of help, but I also get paid again on Friday, and I plan on paying as much of it as I can on Friday.
All right, well, let's talk about that. The law says, sir, could you remove your hat? Thank you. The law says we have to adjourn this matter at least 7 days. So we're going to adjourn it 10 days, if that works for you, Mr. Thornton. Are you available Monday, the 25th at 2:20?
I am, Your Honor.
All right, now, they can also agree to work with you on some sort of a plan to get caught up on the rent. Where are you working?
I work at Fairview Nursing Home in Centerville.
All right, you can probably get all the overtime you want there.
Yes, I
Hang
do.
on.
And that's, I've been working 12 to 16 hours every day to try to catch back up after being off for a little bit.
Oh my. All right, well, it sounds like you've got a plan and you're serious about this. Sometimes people just throw their hands up and say, I don't know what to do. So stay in contact with your manager, Judy. She seems like she's on the same page as you are. We'll see how much money you can pay between now and the 25th. You would then get 10 days from that day to either move or pay the rent. And that would also include September's rent. But they don't have to evict you in 10 days. They can give you up to 56 days to get caught up on this. So we've got some things we need to discuss. but I hope you get a big fat check and make a big dent on this. Just bear in mind, September's rent is just around the corner.
Yeah.
But we'll visit it again by Zoom. You were here early, and I appreciate that, at 2:20 on August 25th.
Okay,
All right, thank you.
thank you.
Good morning. Now, we did the dismissal for Lance.
I think that concludes my stuff.
I think it does. Thank you.
Okay,
All
thank
right,
you.
well, let's see who we've got. Miss Winters, I'll remove you.
All right, thank you.
Oops. And I'll remove Judy. She's gone.
Thank you.
All right, Judy R.
Judge, if I get a
All right.
call from
What's
John,
that?
if I get a call from John Bush, I'm gonna turn my screen off and take it with regard to one of the later cases today. I
All
just
right.
apologize in advance for that.
Mr. Brewer, could you take off your hat, please? All right, let's see who we've got here. We've got Brad, who I'm assuming is Brad Brewer. And we've got Dottie Bosson, Dottie Cruzman. And we've got iPhone. I don't know who that is. Someone's here by phone. Who am I speaking with?
Casey, Big Casey.
All right. All right, the title of this case is Brad Brewer, but that isn't exactly right. As agent for 55431 Franklin LLC. Mr. Brewer, that is a limited liability corporation, and you can't represent them unless you have a law degree. You're acting as a lawyer by representing this company. If it was just Brad Brewer, you could do it yourself. And Mr. Bainbridge, they want you to move. So let's go through the rights and see exactly what we're dealing with here. I know both parties. Mr. Bainbridge, you're a defendant in the landlord-tenant case where your landlord wants you to move. You have the right to hire an attorney. If you cannot afford one, you can request that legal aid represent you or seek other legal representation. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance. And be prepared to pay the $50 jury demand fee. Mr. Brewer, is your vehicle moving?
It is. I'm a passenger in it.
Well, I'm not going to do this while your vehicle's moving. I don't want to have a traffic crash while we're doing this. So pull over if you can. This isn't an inconvenient nuisance. This is a court hearing. All right, I'll continue with the rights. If you have to pay the $50 jury demand fee or ask the judge to waive it for your inability to pay it. This isn't about paying rent. They simply want you to move. You may be able to reach agreement outside of the court through mediation. Both parties are interested. The court can help set that up. And you may be able to reach an agreement that will result in a conditional dismissal. So as soon as Mr. Brewer gets stopped, we'll address this further.
Yeah, we're pulled over to the side of the road, Your Honor.
All right. What is this property, Mr. Brewer?
It's a business. It's R&R Trailers Incorporated. The property is owned by Franklin LLC.
You really aren't qualified to represent them in this matter. Is this the actual factory or is it the showroom out on 131?
It's the actual factory, the shop property.
Boy, you guys need a lawyer for this. Mr. Bainbridge?
Yes,
Is this, you're renting the factory?
just a portion of the back. I have a new place. I just got a new place to go. I've been having difficulty getting it, but I just got it, and then
All right, well, can you vacate within 10 days?
I don't know if I can get it all done within 10 days, but I'm gonna try my darndest.
Well, the law says I need to adjourn this. And I'm going to do that. I'm going to continue this to 8/25/25 at 2:30. Mr. Brewer, some lawyer is going to have to represent you in this matter. You can't represent a limited liability corporation. You could go see one of the attorneys in Three Rivers or elsewhere. They could appear for you at this hearing. It appears Mr. Bainbridge is going to be willing to vacate. I would give you 10 days from August 25th to vacate, which would then include another month's rent. So my suggestion, Mr. Bainbridge, is you make every effort to get out of there by the end of September, by the end of August. What is in this back part of the business?
It's just I just got storage and stuff like that. It's in here.
All right. Were you running a factory yourself out of there?
No, just storage. Just had stored some of my property.
All right. Well, they can certainly rent part of their factory for storage. Now, Mr. Bainbridge, if you move out by August 25th and let them know, we don't even need to have a hearing. But if you haven't vacated, we're going to revisit this. And as I indicated, Mr. Brewer, you're going to need an attorney to cover this hearing for you. And you and your father know who they are in Three Rivers or nearby. If he does move, that takes care of the problem. If it doesn't, we'll revisit on August 25th at 2:30. Do you have any questions?
No, sir.
No, Your Honor.
All right, I'll see you. Hopefully, maybe you'll move out by then and I won't see you, but at any rate, the matter's set for August 25th at 2:30.
All right. Thank you, Your Honor.
Thank you, Your Honor.
What's your name, ma'am?
Christina Dory.
All right. That's set for 9:30. All right, next is Dorothy Clark Cruzman versus Deborah Clutter. That matter is set for $9:40, but Dottie Clark Cruzman is here. Ms. Clark, you submitted an order to dismiss. Did you wish to have this case dismissed?
Yes. Yes.
All right, they checked the box with prejudice. All right, I've signed an order to dismiss that case. And so I won't make you stay here and wait for 20 more minutes. The matter is dismissed. Did she pay?
That was never the issue. She had one
did she
roommate
move out?
that didn't want to move out.
All right.
They had moved out. Yes.
All right.
They
Well, that
moved
solves
out,
that.
Monday. So, yeah, we just want to dismiss the case.
All right. The case is dismissed. You're free.
All right.
Got some sound feedback there. All right. That's 9:40. All right. Our next defendant, Miss Christina Dory is here. We'll see whether Hope Haywood shows up. This matter is set for 9:30. Meg, we gotta let the clock tick for 6 minutes. I see that you filed an appearance.
Actually, Judge, the esteemed, reputable, or infamous Kupferschmidt has.
I do see that. He has a P number of 100001. All right. Well, we'll wait for that.
I offered to. I didn't. Yeah, I was surprised by that, but I guess he maybe had a previous relationship involved. Or legal, professional, whatever. But I was like, well, Rick, you're welcome to cover the docket if you'd like. But Fridays.
We'll see. We'll see what happens.
Yeah, Fridays are his day off, so I let him off the hook.
All right, very good.
But he will be here.
Okay, Miss Dory, why don't you come up and have a seat right here in the padded chair? I used to sit in that chair when I was prosecutor many years ago when Judge McManus was here. You did give me your login information, but I guess you decided to just come in.
Well,
and that's always fine.
Right. I called at 8:30 and they said they had to talk to you. Then I called back at 8:45 and told them I finally figured it out. And they said that I had to be here in person.
Well,
so I don't know.
Well, I'm glad you're here. I would have sent you an email invitation, but you're here and we'll do business the old fashioned way where I look people in the eye. We'll see whether Miss Haywood shows up here. We have an 8:30. We just dismissed the 8:40. We have 8:50. 9:50. Then we have some general civil matters at 10. We pick up again at 10:30. I also have a criminal case I have to address. I tried to take care of it this morning, but was not successful. Two minutes. Don't just show up. Hi, I'm looking for a Hope Haywood. All right, thanks. Bye. Has not checked in. This is filed as a demand for termination of tenancy. Christina Dory is here present with me at the court. Hope Haywood is not here. This is, I think, adjoining properties or nearby properties on Parkville Road. Ms. Dory, what's the nature of this?
We own the house that's at 51510, and we were running it out to Hope. Everything was going good, and then last November, December, they stopped paying rent. They didn't notify us or anything, so I went down and talked to her and found out there were some difficulties with employment and stuff like that. We worked it out. They paid the back rent and then started paying again. Then all of a sudden it stopped again. They stopped communicating. They wouldn't answer my phone calls. They wouldn't answer my texts. They just no communications. Went down there, tried to talk to them. And
well, and when is the rent last received?
the last received was April. So I did.
All right. Elaine, would you prepare a default judgment for me in this case? They have 10 days to move. Until August 26th to vacate, or they're subject to being evicted. She was personally served. Who you say they? Who else is there?
Well, she has her husband and a daughter with a son-in-law and 2 children, apparently.
Well,
I was only running it.
And there's no lease.
She signed some papers 2 years ago, and we haven't had anything signed since then.
So you rented just to her, and then she moved in all these other people?
Yes, then a bunch of other people moved in.
Well, this isn't the best way to do this. You really should have a lease. They were personally served with a termination of tenancy. They got a notice to quit. My notes. Some months ago, back in June, I believe.
Yes.
Notice to quit was June 3rd. So they've known this was coming. They haven't paid any rent since April. So I'm asking my clerk, Elaine, to prepare a default judgment, and I'll sign it, and you can take it with you. After August 26th, if they're still there, you can bring $15 to the courthouse and ask for a writ of eviction.
Okay.
And the sheriff will come put them out if they aren't out. All right. So as soon as she brings that to me, I'll sign it. And when's the last you actually had any contact with them?
Week and a half ago, I got a text from her son-in-law saying they'd be out by the 14th.
All right. Maybe they are.
They have not returned the keys, and there's still stuff on the property and inside the house. I have not seen them.
All right. All right, I'll mark. I got it right here. All right, Miss Dory, if you go out to the counter, you can have this batch too. She'll give you a copy of that order and then you're good to go.
Okay, thank you very much, sir.
Just a moment to prepare, okay, ma'am?
Okay, go to 107.
Yes.
Yep.
Okay.
Ella Enchanted, our summer office intern, is leaving today. She's going back to school and she's also got a very nice job offer. And today's her last day. So we have cookies and some other stuff back there. So Ella's done a great job for us. Her capabilities exceeded our expectations and she got assigned more duties than we originally thought she'd be doing. So she's been a big help to us while we had staff off. And I wish her the best. She didn't bring the cookies, but they do have some. Let's bring in Mr. Rognus. Mr. Pearson was here briefly. Good morning, Mr. Rognus.
We got any defendants on our 950 yet?
No, we got 3 minutes to tick here.
Okay.
We were in pretty good shape. We had a little bit of a gap between cases. One case got dismissed. We'll do 950 and then we got some general civil matters and we'll pick back up at 10 o'clock or at 10:30.
Well, this is kind of an odd case. This is not recorded land contract, and there hasn't been any payments on it for a long time. I mean, the payments are hit and miss. So you got to go way, way back to start applying where the payments go on. And summer 2025 taxes just rolled onto it also. And I do have personal service on one defendant posted on the other.
Let me look at my notes. Personal on
Catherine.
Attachment on Herman.
Correct.
All right, well, we'll let the clock tick here. We've had a dead air. I mentioned before I brought you in, our intern, Ella, is leaving today. And today's her last day. So they had some stuff in there.
Was she just for the summer?
Well, she'd been here through part of last semester and then through the summer. She's done a very good job.
Hey, did I see Lucas is going to be our guest speaker on, what is the 8th?
So it appears. You're the one that stirs things up all the time. So apparently you instigated that.
I think his information is going to be really beneficial to the average practitioner. I get asked questions about that stuff at least twice a year, and I got no clue. It's kind of like, a dark art to know that kind of stuff.
Well, it is pretty arcane. He wrote the ICL article on the topic. He just came back from the treasurer's conference, and he meets with the treasurers a couple times a year and tries to keep them apprised of the law. So yeah, that'll be nice. He's actually,
I was gonna say, his brief helped me a ton in a case I had over in Van Buren County with one of those tax protester people.
all right, well, it is 9:50. Let's call your case. We're gonna have to adjourn this anyway because we don't have personal service on one of the defendants. This is Terry and Larry Richmond versus
No,
Herman.
it's not Terry and Larry. This is the other Terry.
Oh, the other Terry,
This
yes.
is the brother-in-law Terry.
Terri Richmond is one of our, no, she's one of our preeminent landlords. She does a good job representing herself. She has a brother-in-law named Terry, Terry, Terry Richmond, who is the plaintiff in this case. The defendants are Herman Cooks and Catherine Newsbaum. This is a property on Parkville Road that has what Mr. Rockmis refers to as an unrecorded land contract. Seems to me we had some litigation on this case in years past. At any rate, they're substantially delinquent in the terms of the contract. They've paid less than 50%. But we do not have, we have personal service on Catherine. She'd be subject to default, but we have only attachment service as to Herman. So we need to continue. And Andy, I'm not going to be here next Friday, but I will be here Monday, August 25th.
As long, well, I got my 10 o'clocks with you anyway, so anytime on Monday other than 10 o'clock.
All right, well, let's set it for Monday at 2:15. Monday, August 25th, 2:15 p.m. expected default.
Yeah, and I think I've already sent a judgment over. It just does not have the summer 2025 taxes, which is an additional $411.79. And I guess I got a quick question. The contract requires insurance, and I don't know how you do that. Is that something where the vendor acquires the insurance and then charges it back?
Well, they can, whether they'll be able to collect on it. Right now, they're probably running naked without insurance on this property. They can certainly do that and then attempt to charge it back. But we'll address that when we visit it on the 25th. So they'll have 90 days from that date to either redeem the contract or vacate. But I'll see you at that time. Thank you.
Okay.
All right, thanks. Meg, I'm going to shift into a couple of general civil cases. They're difficult collection cases where the defendants get an installment agreement, they don't pay, plaintiff asks for a writ of garnishment. We'll pick up LT again, well, with Rick, I guess, at 10:30. You want me to put you in the waiting room or just let you go on about business?
I'll just shut my camera off, then I won't be on the screen, but I'll be here if needed.
All right, thank you. All right, we had about 20 cases set for this morning. The calendar shows 2 discovery subpoenas at 10. I don't have those files, so I'm thinking maybe they got moved. I think Attorney Bradley Johnson is here on behalf of Credit Acceptance Corporation.
Judge, I took them off because Lena Espinola during those.
All right, very
One
good.
person's settled and the other way she can't locate.
All right, thanks. 2 less things to worry about. Instead of 4 cases, we have 2, which is better.
Case number 25 CR 42552. Present before the court is Mr. Brown, right?
Yes, sir.
Represented by Mr. Huss, and we have Mr. View from the prosecutor's office. We're here today for a pretrial, but it's my understanding Mr. Brown is going to be entering a plea of guilty to 1 count of failure to comply with, 2 counts of failure to comply with the order of a signal police officer, and that there's a joint recommended sentence of 24 months in prison consecutive for a total of 48 months. Is that accurately stated?
Yes, Your Honor, we have an agreement the defendant will not request nor be granted a judicial release.
All right.
That's all correct, Your Honor. That's all correct, Your Honor.
All right. Mr. Brown, how old are you?
33.
How far did you go in school?
11th grade.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medication?
No, I'm not. No, I'm not.
Are you a United States citizen?
Yes, sir.
Other than what I just talked about, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Hust before you signed it?
Yes, I did.
Are you satisfied with the representation that you've received in the case?
Yes, I am.
You're going to enter a plea of guilty to 2 counts of failure to comply with the order of a signal of a police officer. They're each 3rd-degree felonies, punishable by 36 months in prison and a $10,000 fine. There's a joint recommended sentence, which I'm going to go along with, of 48 months in prison without judicial release. It also carries with it a mandatory period of post-release control of up to 1 to 3 years, and it carries with it a mandatory license suspension of anywhere from 3 years to life. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at this trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to this 48-month sentence. Is that what you want to do?
Yes, sir.
Mr. View?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on 2 separate occasions, one on October the 2nd of 2024, the other on November the 16th of 2024, both on Interstate Highway 75 in an area located within Warren County in the state of Ohio, that the defendant did operate a motor vehicle fleeing from a police officer with activated lights and sirens. He operated his motor vehicle at high rates of speed in a manner that created a substantial risk of serious physical injury to persons.
Anything on those facts, Mr. Hust?
Nothing on the facts, Your Honor.
Mr. Brown, did you hear those facts?
Yes, sir, I did.
Do you admit they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea of guilty to these charges?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to go into the matter of the sentence today?
No, Your Honor.
You have a jail time credit figure?
I don't think he has any credit on our case. He's been in custody in Hamilton County since the entire time our case has been pending.
All right. So, Mr. Brown, if you get to the institution and you think that you did not get credit either from here or something, you get credit for every day that you do in jail somewhere, but you don't get it in both places. So if they don't give you credit for it in Hamilton County, you get credit for it here. If you get credit for it here, you don't get it there. Okay? You can always send me a letter that says, hey, this is what happened. I didn't get all my jail time credit, and I'll take a look later.
Okay.
Anything else from the state?
There is a class 2 license suspension on each of those. We didn't specifically discuss that, but it's 3 years to life on it.
Mr. Huston, anything else from the defense?
No, Your Honor.
Mr. Brown, anything you want to tell me?
No, sir.
All right, I am going to impose 2 24-month sentences. They are going to be consecutive to one another for a total of 48 months. I find that a consecutive sentence is necessary to properly punish you, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. I'm not going to impose a fine. I am going to impose a costs, and I'm going to suspend your license for a period of 8 years. And during that 8-year period, I don't have the ability to give you any driving privileges whatsoever. And also, you're going to be subject to a mandatory period of post-release control. That means the adult parole authority is going to supervise you. And if you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically, whichever of those is the longer period, it's automatically consecutive to the sentence that you would receive for the new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. Good luck to you, Mr. Brown.
Thank you, Judge. Your Honor, did you say there would be costs?
Yes, costs will be assessed.
Very well. Just want to make sure my notes are straight. Thank you.
Good morning,
Good morning.
Your Honor.
Are you on both credit acceptance cases or just the Rucker case?
Just the Rucker case, Your Honor.
All right. I'm not sure who's got the other one. It was Richard Ruson's office. Yeah, are you in some other courts this morning or you just got us here?
Just you guys this morning.
All right, we'll be done with this, I expect, very shortly. Good morning. Again, I'm looking for a civil litigant, DeLorean Rucker. How about John DeLorean? All right, thanks. Bye. Neither one of them are here. I think he's actually passed away. All right, it's 10 a.m. It's time to call our 10 a.m. cases. First, we have Credit Acceptance Corporation versus DeLorean Rucker. File number is 251173. I checked with the bailiff. DeLorean Rucker is not present and hasn't otherwise logged in. This is a motion for summary disposition and a fairly significant, at least for our standards, amount of money. The lawsuit was filed against the defendant, and the defendant filed an answer detailing the struggle she had in a previous relationship. And I think she might actually have been a co-signer for this and was greatly encouraging the plaintiff to also file against the main signer. But she is co-signer. And unfortunately, appears to be stuck on this loan. The amount prayed for is in the order. Summary disposition is requested in the amount of $12,583. That consists of the balance and damages of $11,680, filing fee of $160, motion fee of $20, service fee of $70.83, and the statutory attorney fee of $75. Mr. Johnson, are you going to ask for a default at this time?
Your Honor, no. It's a weird situation. I know you read the answer. We have reached a resolution with Mr. Fuller, the co-signer. He is supposed to make a settlement payment on or before September 25th to resolve this. So, and I don't know this guy, but I feel like I do from the answer. I don't know if the court wants to push this out to allow him to make this payment, and then if he does, we can dismiss against Miss DeLorean or whatever the court wants. But I wanted to put that on the record.
All right. If he does, this case can be dismissed. If he does not, can pursue this judgment. All right, John DeLorean, Darius Rucker, DeLorean Rucker, none of them are here, but I will continue this matter until about September 29th. Well, that might be too soon. About October 6th at 9 a.m.
That works, Your Honor.
All right, we'll see what happens. If it is, let's see, here's somebody called iPhone. I suspect it's Chelsea Beer, our next defendant. Yes, it is. All right, Mr. Johnson. Are you Chelsea Beer?
Yes.
All right, you're a minute or two late, but not too bad. All right, we'll continue that one until October 6th and see where we go with that. Thank you.
All right, thank you, Your Honor. Have a good day.
Our next matter is Credit Acceptance Corporation versus Chelsea Beer. Lynn Olivier is here on behalf of the plaintiffs. We sit here every once in a while. Good morning. Welcome back to Centerville.
Good morning. Thank you. How are you?
I'm pretty good. We are about on schedule. This case is a case of deja vu all over again and all over again. It's entitled Credit Acceptance Corporation versus Chelsea Beer. File number is 22919GC. Plaintiff has filed a motion to set aside an installment agreement and enter a garnishment. The debt is substantial. It was north of $14,000. The actual judgment was for $18,822, something like that. I can't read it. Defendant entered into a repayment agreement where she would pay $50 every other week, which is not really that big of a payment on an $18,000 debt. But the plaintiff accepted that. Defendant was unable to pay that. There was a motion to set aside installment payments. The defendant wrote a letter. We didn't set it aside. Then there was another hearing on motion for installment payments, which is pending now. And the defendant wrote another letter, date stamped July 28th, explaining her circumstances. And here we are. Defendant contends she doesn't have enough money to even pay her rent. And the plaintiff wants to garnish her wages to collect on this debt, and the garnishment would be substantial. So
Actually, Your Honor, things have actually changed even since that letter. I lost my job on August 1st, so there's no employer to garnish from.
all right. Have you discussed any of this with like a creditor's attorney, like a bankruptcy attorney?
I have, but the retainer fee to start is what I don't have.
Yes.
Your Honor, I have a suggestion.
All right.
Seeing as she just lost her job, I assume she is currently looking for employment. If we want to adjourn this 60 days to see if she's able to obtain new employment, see what her situation is at that time, maybe she can continue or even increase a payment order. I'd be fine with that.
All right. Ms. Beer, what do you think about that?
Right now, because that happened, I'm going through different agencies to try to help me catch up rent. So at this point in time, I don't even know if I'm going to be living where I'm at or if I'm just going to have to quit my lease. So therefore, I don't even know where to get a job at this point. If I'm supposed to get a job over here in Bristol Elkhart or if I'm supposed to go back to Sturgis and get a job. So everything is just up in the air. I'm waiting for unemployment to come through. My daughter's supposed to get supplemental Social Security, but that got taken away because of resources. So I applied to get that back. I'm waiting on answers on that. And then, like I said, I'm going through the hub over here in Bristol and Salvation Army and the trustee over here in Bristol to help me catch up rent. It's just been rough since I moved over here because I was used to paying $550 a month.
Yes, you went from $550 to $1,100 a month, so your rent doubled.
Yeah.
And then you lost your job. And this is a situation where if they garnish your wages, it wouldn't even be worth working. They would take so much from your wages, you might be better off not even having a job. So you are really between the proverbial rock and the hard place. This debt isn't going to go away unless you address it through bankruptcy or some sort of repayment agreement. The repayment was very generous because a debt of this size probably incurs $100 a month in interest. So you're on the, and I don't know if they were excusing the interest or not, but it would take.
No, I don't believe so.
So right now, you're not even barely covering the interest. You're probably paying $5 a month on the principal. But Ms. Olivier's suggestion that we adjourn this for 60 days and see where we are. I could enter the order setting aside the repayment agreement, and then if you got a job, they could garnish it. But that would make even worth you getting a job.
Plus, wouldn't that affect unemployment if I started getting unemployment before I got my issue resolved here? Would they take that from unemployment?
I don't believe so. I'm not on that, but also not clear what the law is in Indiana. So let's see where you are. Where were you working?
I was working at Warehouse Designs in LaGrange, Indiana for 2 years.
I'm not sure what they did.
It's like a print shop, like screen print and embroidery.
All right. Well, 2 months from now, I'm going to set this for, this is August 15th, September 15th, October 20th at 9 a.m. Reset. See what defendant status is at that time.
Yeah, and I'm not saying the payment was undoable, but sometimes when you're looking at $100 to go on for a week and it's food and gas, becomes undoable.
I understand. I understand. So they're interested in collecting on this big debt. You're interested in feeding your kids and paying your rent. Sometimes the two things don't. If you had a big pile of money, you'd just pay this off. But right now, you're worried about losing your house. So let's see where you are in 60 days, and then we can make some further ruling at that time. All right. So I gave you, if you do move, please let us know of your change of address.
I will.
All right. Thank you. Anything further, Miss Olivier?
Oh, Your Honor.
All right. Thank you. I'll see you next time.
Okay, have a good day.
We're working on it. It is a beautiful day outside. I'm in a room with no windows in it.
You'll enjoy it at some point.
I hope so. All right. Thank you.
Versus David Banks, Casey numbers 21 CR 38825 and 22 CR 4000. Present before the court is Mr. Banks, right?
Yes, sir.
Represented by Ms. Hinkle. We have Mr. Harrison, the prosecutor's office, Officer Evans from probation. We're here today for a final violation hearing. Ms. Hinkle, does your client wish to have a contested hearing in this matter?
Not at this time, Your Honor. He will admit to the violation.
Mr. Banks, do you understand the rights that you're giving up by admitting to the violation?
Yes, sir.
Is this what you want to do?
Yes, sir.
Do you admit or do you deny that you violated the terms of your probation?
I admit it, sir.
Based upon your admission, I find you have violated the terms of your supervision. What's our jail days as of today?
350 jail days and 321 prison days, Your Honor.
Mr. Harris, anything from the state?
Your Honor, as the court's aware, this was a judicial release case. You gave him an opportunity to be out in the community again. That obviously has proven that he cannot abide by the rules. I think this is out of the gate was a recommended prison sentence from the state. The fact that this defendant was given an opportunity and proved himself not to be able to comply with rules, we would recommend that he be sent back to prison at this time and be violated.
Officer Evans, what's your thought about this case?
There's the recommendation of probation that Mr. Banks complete residential treatment with Sojourner. He has already been accepted to that program. It would also be recommended that he, after the completion of residential treatment, that he engage in some type of recovery housing or sober living as aftercare. He has not picked up any new charges since his release from prison, and I believe that he could benefit from residential treatment.
Ms. Hinkle?
Thank you, Your Honor. I've spoke with Mr. Banks, and since he has been out, this is his first violation. He did take accountability for the substance abuse, and he did admit to his probation officer that he had used the methamphetamine. After speaking with him, he is really interested in getting treatment and help. He was accepted to Sojourners, as Ms. Evans stated. So I would just ask that you give him an opportunity to get the help that he needs through the treatment center, Sojourner.
What do you want to tell me, Mr. Banks?
Your Honor, I apologize. I do take responsibility for my actions. I lost my footing. I'm sorry. Sorry.
So on December the 18th of 2023, I received an email about this case, and the email reads as follows. It ends as follows. I do not believe that Mr. Banks is amenable to community control, given his past performances, his enabling family members, and the fact that he committed new offenses while under community control supervision. We're in the same place as we were in December of 2023 when I received that email when I was trying to decide whether or not to grant you judicial release. And it just tell me, Mr. Banks, how we have moved this case forward at all since December of 23.
Your Honor, I went to prison, and during my time at prison, I had a chance to reflect, and You granted me the judicial release to come home, and I was grateful. And I did 15 months with no violations. Like I said, I don't have an excuse for why I did. I was just going through a lot, and I slipped. And I'm grateful for the judicial. You know, I've got to get back in my son's life. I was doing visitation court, and I understand why you're upset with me. I do understand why you're upset with me. I also know that in the past I wasn't getting along. I had a problem with authority, and I was just being ignorant. Honestly, I was just being plain dumb. You blessed me with Hillary Evans as my PO, and she has been a blessing, and she's helped me. I don't want to get high. I really don't. I don't want to be here no more. I don't want to be sitting in front of you, Your Honor, begging for freedom. I really don't. I don't want to go back to prison. I don't want to miss my kids' life.
But the Evans plan is a total break with life as you know it. A total, we are going to do something entirely different with the life of Mr. Banks, that you're going to go to treatment, you're going to get out of treatment, and you're going to go to a sober living. And then when you get out of a sober living, you're not going back to grandma's. And we think that that is a bad place for you. You've been working with the uncle this whole time. Maybe that's not the best way to go either. And this seems like something that's a radical change for you. Are you ready for that?
I'm blessed with a mother that's sitting behind me, and I have an address in Warren County that I can go to not go back to grandma's. I'm willing to, if you don't want me working, like I was working back at Snyder's so I could get my child support paid. I was working with my uncle though, and my uncle and my nephew whenever I got out, but I left them and went back to Snyder's. I think that might have been a mistake, honestly. If I don't want to go back to grandma's, I'm fine with that, Your Honor. Like I said, my daughter and my two daughters are at my mom's. Well, my youngest daughter is at my mom's. I can be with my family. I'm willing to try do whatever, Your Honor. I promise you.
Well, Officer Evans's point is well taken. I know you didn't hear it. She made a good point back in when we were talking about your case getting ready for today, which is if I send you to prison, you're going to come out just as bad, if not worse. That's probably not the way to go. I get that. So we're going to try the Evans plan. I'm going to keep you on probation. I'm going to modify the terms of your community control to order that you enter into and successfully complete the Sojourner program. You are then going to complete a sober living that we're not going back to grandma's. You're going to get hooked up. Let's get them hooked up with the employment folks, and let's go a different direction entirely on employment. Not Uncle, not Schneider's. We could find a job for them somewhere. I'm going to give you credit for the time that you have already done. And let's set this for a probation review. Let's continue and react. We need to probably extend him to the max date. So let's move him to a 5-year community control on both of the cases and set it for a probation review when he gets out of Sojourner.
Your Honor.
Yeah.
Can I get an ankle monitor for at least 60 days, please? To mom's,
I'm confused. We're not going to Sojourner?
No, I'm going to Sojourner. I'm saying afterwards.
Oh, yeah. When you get released, whenever you start to get privileges to be able to go anywhere other than being in a treatment facility,
yes,
then you're going to be placed on a monitor.
Yes, sir. Okay. Thank you, sir.
All right. Anything else?
No, Your Honor. Thank you.
All right. I'll see you when we get out of Sojourner.
Thank you, Your Honor.
Thank you.
Thank you.
Ms. Hinkle, the continuing hearings on probation are not part of what you do, so you can just go ahead and bill us. You're done in the case unless there's a new violation.
Thank you, Your Honor.
All right. That's all.
Thank you, Your Honor.
All right, that brings us to our next hearing is at, we got a lot to do. We got a 9, 10:30, 10:40, 10:45, 10:50, 10:55.
That's the list.
Push.
Morning, Chris.
Good morning, John. Good morning, Your Honor. Whoops.
Good morning. John, we've got 5 cases for you. We've got them set in short order. We'll see how we do this morning. We've got 4 minutes till our next case with Mr. Fenwick. We've got 1 Memory Lane, 2 V Squared, an Eric Pearson, and a Mayor's Home Rentals.
That's the list I have. Chris, any activity with Mr. Fenwick?
Yes, he has paid a total of $3,000.
That's a good sign.
Yes.
Here is Christine, named the car after her. And King dead. All right. This is Memory Lane Mobile Home Park versus Matthew Fenwick. We had a hearing on this on August 1st. The matter was continued until today. At that time, the defendant's arrearage was late fees, costs, and rent, $4,956. He's present with us here today. According to the manager, Chris Corpening, the defendant has paid $3,000 since our last hearing. Is that correct, Mr. Fenwick?
Yes.
So if we add that in, it would be $1,535, $240, $180, $120, and that would be $1,956.20, I think.
That's the number I have, Your Honor.
Mr. Fenwick, that shows great good faith on your part, making a substantial payment on this. Is it your intention to pay the rest of this by the date in question?
Yes.
Very good. Now, you had been sick, but you're doing better now?
Yes, that's correct.
John, I have a judgment in your other cases. Let me look and see if I've got one on base that I'm not finding. I don't have one in this.
We will get one over if you don't have it,
All right.
Your Honor.
All right, well, let's talk about that. That is 1,535, 240 in late fees, 180, 120, and cost for a total of 1,956, due 10 days from today, which would be August 25th. Mr. Fenwick intends to pay that. Now, Ms. Corpening has some wiggle room here. She does know this. She has up to 56 days before she has to ask for the writ of eviction. Of course, on September 1st, a new month's rent is due. So, John, I'd ask if you'd give me that this afternoon, or at least as soon as possible, because I'll be gone for a few days and I don't want to let this order languish. So, Mr. Fenwick, my advice is always the same. Stay in contact with your manager. Sounds like you're going to get this squared away. However, if you do end up moving, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. Do you have any questions?
No questions.
Are you at work right now?
Yes, I am.
All right, good. We'll let you get back to work so you can pay your rent.
All right, thank you.
All right, very good. On to send judgment. All right, thank you. All right, I think that's it for memory lanes. Let me remove Mr. Fenwick. There, he's gone. I'll remove memory lane. All right, next up for us, John, is V Squared Ventures, and that is set for, it's not right, 1040. And we're 1045. Only, I believe. There's something. Good morning, Miss Fitterman Rarick. Is your car moving?
Yes.
All right, I'm going to ask you to pull over. I don't want to have an accident while we're doing this hearing, even though you're a passenger. I don't do this when the cars are moving.
Okay, sorry, I didn't know that.
All right. Well, as I said, it's a court hearing, not an inconvenient nuisance. So, but I don't want to have an accident. So, all right, we'll let you, I'll put you in the waiting room for a minute.
Okay.
Good morning.
Good morning. I was seeing if Nick was in here. Oh, you're in court, I'm sorry.
Who are you looking for?
I was looking for our attorney, Nick. We have neighbors of Washburn.
Oh, I haven't seen him yet, but welcome. Good morning.
Should we sit outside here?
No, you're welcome to sit in here. It's a public courtroom.
Okay.
That's the lawyer's side.
Well, we're with our okay.
All right, let's see who Motorola Moto G Play. Who am I speaking with? Someone.
Natasha?
All right, Natasha Hively.
Yes, sir.
All right, I really don't like doing this by telephone only, but let me give you a name. All right, we're waiting for Mr. Kupferschmidt, who we hope will join us shortly.
I talked to him yesterday. I do believe his portion of the case is going to be resolved this morning.
All right, very good.
He's
Yes, but he's here. He's had some trouble in the past logging in, so let's make sure we're squared away with him.
Court cost, a $500 fine, a $300 attorney fee. I assume we had DNA. Is that correct, Mr. Denon?
Yes, sir. Your Honor, I'm retained.
Oh, I thought it said appointed on there. I double check.
It may have, and I didn't catch it.
It says appointed on CFJ 145, page 1.
I'm retained.
Thank you. We'll go ahead and make that change. I'll strike the attorney fee. Thank you very much for letting me know. There's a supervision fee of $30 a month or $60 a month if there's any electronic monitoring. So that leaves just this question of any period of confinement. We're in an intermediate sanction cell. The court does not need to find reasonable grounds. However, the court still must discuss its reasonable proportionality based upon the defendant's prior criminal history, its repetitive violations of bond, violations of probation, violations of home placements, going AWOL, the issues that it continues to be a challenge of impulse control. The court finds that the defendant isn't learning his lessons as well as he should. You're going to need to find a way, and hopefully Ms. Otel helps get you into some kind of anger management type of program so we can get you some understanding. So when you start to feel that switch flick, you can calm yourself down, go for a walk, maybe your wife, your girlfriend, fiance, whatever she becomes, ties you down, I don't know, locks you into a room. I'm sorry, that would be unlawful imprisonment. But hopefully she comes up with something that's effective to work. I still believe that a period of confinement is appropriate. You're looking at a straddle cell. There is absolutely no reason for me logically to not give you a prison sentence, but I'm not going to. Obviously, I already given you probation, so everybody here knows what's going on. I haven't heard anything today from the victim, so I want to make a note of that. Without hearing from the victim, I don't have much to swing me the other way. And I'm not criticizing the people, of course, with that, or even the victim. But I'm just saying, obviously, I don't have anything to swing the factor the other direction. The court sentences the defendant to a period of jail for, I'm going to say, one moment. While I respect and appreciate Ms. Otel's recommendation, sometimes I like just to differ so no one expects me to always adopt what the probation officer says. The court sentences the defendant to 210 days in the Missaukee County Jail, and the defendant receives the credit listed, which was 3 days. In that by the way, for probation, you have the right to be considered for early release from probation if you are satisfying all your terms and conditions at 18 months. The fines and costs are due within 59 days. 56 days. I knew I said that wrong. And if you don't pay them, then an assessment of 20% can be added to it. But as long as you're compliant with probation, you can work on a payment schedule with them, and I won't add the penalty. Now you're going to get obviously good conduct time credit, so it's going to be less than 200 days. It should be down to 180 days. All right. I hope that you take some time to think about things, write down some goals, maybe start journaling a little bit, things that you've learned in your life, things that you thought you learned for about 3 or 4 years and realized because of this, holy cow, I didn't really learn them. Or maybe I addressed one set of issues, but not the next set of issues. And while I can't order you to, maybe write a letter to your son today or sometime over the next couple months, or continue to write him a couple letters. He's going to know about your past. There's nothing wrong with him knowing about your past. Let him learn from you and how you deal with them and how you move forward. We all really hope that this is the last time you ever have to come into a courtroom for an involuntary reason. I guess that's the best way to say it. All right, thank you. Anything further, Ms. Otel?
Your Honor, the thing is, Mr. Cherry had mentioned there's no longer work release in jail. I don't know the jail rules, but I would not be opposed to work release.
If he qualifies, if he qualifies, I'll approve, I'll authorize it. All right, Mr. Cherry's going to bring to you, Mr. Young, 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of the other copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the previous case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. You understand?
Yes, sir.
All right. Today went better for you than I had my suggestions and ideas on. Not really, it's basically because I thank you, Mr. Cherry, for catching the GED portion and you filling in the gap about employment. That's what kept you local. Yes, sir.
Would the court consider, with the baby due in September, a furlough at the time of the birth?
If you get there at that time and the prosecutor agrees and stipulates, of course, I'll grant that. Okay. All right. We'll do generally what we'll do is we'll put them on tether for a couple of days or a day or two. I might say 2 days because if we want to give you, well, anyways, you all figure it out. I'll authorize it. I think that's fair and appropriate because what I'm really wanting here is just to help his child. That's what today's sentencing in my mind is all about. Well, helping him so he can help his child. Thank you very much.
Thank you, Your Honor. May I approach?
You may. Thank you. Our next case here is People of the State of Michigan versus Dwayne Swisher. I talked way too much on that last file. We were on time, Nancy, and now I've blown it. This is case number 25-3594FH. Appearances, please.
Thank you, Your Honor. David Inhofe on behalf of the people. Robert Champion appearing on behalf of Mr. Swisher, who is standing to my left. Your Honor.
Thank you. You all may be seated. Court also recognizes this morning Ms. Laura Odell. She is the agent from the Michigan Department of Corrections here today, and I think she's covering for. No, she's not. She's not covering for anybody. All right, we're here today for a sentencing in this case. Mr. Denhoughton, did you have any amendments, corrections? Well, hold on. On CFJ 284, page 7, for status of at time of offense. The offense occurred on March 15th. Of 1996. Looks like he was on probation for entry 5 of 9. Got off of probation in that case on June 3rd of 96, 3 months after.
I see that, Your Honor. Thank you.
Thank you. All right. Mr. Denham, any amendments, corrections, or objections to make?
Your Honor, I have received the PSI report. I've reviewed it and I have no proposed corrections, additions, or deletions.
Mr. Champion.
Same for defense, Your Honor. We reviewed the report. We have no additions, corrections.
All right, we're here today for a sentencing on a possession of meth charge. Allocution, Mr. Champion.
Your Honor, as the report indicates, Mr. Fleischer in the past has a history of substance use disorder. And what he's learned through that is in this particular case, he shared what occurred in this case with family, friends, and employers. He continues to work full time. Also note that he's been testing regularly. He did have an issue back in June. That is because he works and lives in Muskegon and he came up to Cadillac test. He was late for those testings. Since then, he's had no violations whatsoever. And even that violation, he never tested positive for any controlled substance. I think what's also important, and Mr. Fleischer, is the individual who introduced in this particular case the controlled substance to him. He went back to his employer and also where he resides. That person is no longer around, had to move and get away from it. So he's changed his people, places, and things. He's taking his sobriety seriously. He shared it with the community. He continues to work 2 jobs throughout the summer, and in jobs that we have historically thought would expose people to substance use. But he has maintained his sobriety and is doing well. I would ask for a term of probation in this matter with no additional jail. I would also note that since he's testing in Muskegon, the cost per test is $45, and he's been covering that cost throughout that. So he is responsible. He is taking this serious. So I would ask for a term of probation, Your Honor.
Mr. Down?
Thank you, Your Honor. As I referenced in the PSI report, back in April, there was a traffic stop, and during the course of that stop, a pipe fell to the ground from the defendant. It ultimately tested positive for methamphetamine. We do support the recommendation, Your Honor. We respectfully request the court follow the recommendation as indicated.
Thank you. Mr. Swisher, you have the right to make a statement if you choose to do so. Is there anything you wish to say today, sir?
No, sir.
Now, there is one thing, I could have said this before, but I'm going to correct it now, that nobody else did. And I'm using it to highlight the situation for Mr. Swisher. On CFJ 145, page 1, what needs to be changed? At the bottom, underneath methamphetamine, it's no longer 2023, 2025, which is because, of course, he got with methamphetamine. So it's a small point, but it's a point to me that you need to put end dates on things like this. Not only so we know, but you know that that's an end date and it needs to stop. So, Mr. Swisher, there's a lot of negative to say. Sentencing is not always meant to be negative. You had a period back about 30 years ago where you could not seem to stay out of trouble or stay out of your own way, right? Right. Theft, assault and batteries, probation violations, bond violations, multiple trespassing, unsuccessful discharges from probation. That continued from 1992 throughout the 90s. And then into 2000, then you had a significant gap in time. It went about 17 years. So you had a really, I think I can use this word, crappy 10 years, followed by a good chunk of good years. Then you screwed up, and it's substance use disorder is something Mr. Champion mentioned, and is correct. I encourage you, and while I'm going to make a term or a condition of probation that you can't use marijuana, I can't stop you from medical, but I can stop you from recreational. And there's a reason. I'm also going to include alcohol, even though I don't see alcohol is stopped about in 2020. If you're using one substance to cover up your feelings for another, and you're just exchanging substances, My dad had a story. He used to work for the highway department. And he would tell me, I'd ask him about those little black marks on the road where they just would fill in the cracks. And he'd tell me, you can cover the crack, but you still have a crack in the road. You just covered it up with a bunch of tar. Well, if you've got something in your life that's causing you to have issues with substances and you just move to ones you think is less impactful, you still got a crack in your road. So I hope you figure it out. But that's all up to you and counsel and so forth. Yeah, the hiccup here, and it's a very big hiccup because you've got significant prior criminal history. Now, I will say here, I didn't really understand what your work history was. Well, at least you got a job. Where's he working now, Mr. Champion?
The G&L Property Management and also for M&M Concessions.
I'm gonna hope, Mr. Swisher, I'm doing the right thing. I think there are reasonable grounds to give you jail based upon the problems that you've had in the past with rehabilitation. However, the court is going to sentence you to 24 months of probation. I adopt the terms and conditions listed on CFJ 145, pages 2 and 3. I find that those conditions are well suited for rehabilitative purposes, considering your history and this case. The court sentences to a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee, a supervision fee of $30 a month, or $60 a month if there's any electronic monitoring. The court sentences you to 4 days of jail with the 4 days of credit. Did I miss anything, Ms. O'Day? Ms. Otel?
No, Your Honor, thank you.
Mr. Down?
Your Honor, it doesn't appear, I just looked at the lien report. It doesn't appear that there's a DNA on file, perhaps because the prior felony is so dated. So we would ask that fee be added.
All right. Actually, you probably don't do this enough to know, but did you have a fingerprint order over there? If not, Mr. Denhouten, if you would please present to the court a fingerprint order DNA order.
I will do that in short order, Your Honor.
Thank you very much. The court will order that you provide a DNA sample. It's very uninvasive. They just take a swab of your cheek. I said fingerprint, I meant DNA. It was my fault. It's all right. Mr. Denhouten will prepare the order. I'll sign it. You'll get it. And I'll add the $60 and we're going to have you get it done here at the Sheriff's Department. Okay. Any questions?
No, sir.
Mr. Denhouten provided to me a notice of appellate rights. It appears to have your initials there about halfway down. Are those your initials?
Yes, sir.
I need to inform you that you have the right to appeal your conviction and sentence. That is typically done by filing a claim of right to appeal. However, based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the copy that Mr. Champion provided to you. He's shaking his head and looked over, so I know you've got it. You have the right to be considered for early release from your probation at halftime, as long as you can comply with all your terms and conditions. All fines and costs are due within 56 days from today's date, or a 20% penalty will be added. If you choose to make them through payments, you need to work with your probation officer. As long as you are making those payments and you're up to date, then I will not assess that 20% penalty. Do you understand?
Yes, Your Honor.
Do you have any questions about what we've done today?
No.
All right, when you leave here, smack yourself in the face and stop doing stupid stuff. Well, hold on. That sounds like I'm trying to encourage somebody to hurt themselves. Geez, I got to be so much more sensitive. Well, don't slap yourself in the face. Maybe just point your finger in the mirror. Thank you very much. We're adjourned.
Thank you, Your Honor.
Our next file this morning is people in the state of Michigan versus Christopher Neman. file 25-3612FH. Of course.
So because Mr. Neman's about to be elected, Mr. BJ is already clerk, this is ineligible. They also say he's not even if he didn't do that, this is in trouble, but I don't know if it's like-
Yeah. So the question is, does he withdraw? Either both.
Well, or we're going to let him do a delay and do a very similar.
Correct. I understand. I'm sorry. Thank you. Yep. And so the question here is whether or not I would put him on a delay. So you would amend the plea agreement today to say placed upon a delay. Then I would turn and say, does the defendant still wish to keep his plea, knowing that this has changed?
He does, as long as the delay will include the 30 days of jail once he's successful, because he's in the middle of work and he has a master's degree.
Let's walk through part of it, and as we do, I'll think about that. All right.
Okay, and then if you don't, then I would like to.
I got it. Yeah, I figured. Thank you. All right, appearances from counsel, please.
Thank you very much, Your Honor. I'm Robert Ranch, Assistant Prosecutor for Missaukee County. And before the court begins, I know that we do have Christy Weedman that is in the court. The court rather just have her dismissed and put Plea on there.
I'm sorry. Repeat that again. You blurred out there a little bit.
I'm sorry. So pre-trial is set for Christy Weidman.
Oh,
this morning.
You want to take that plea first?
I understand she's willing to put a plea on. I'm okay with going with Mr. Neman first.
Yeah, we're going to stick with Mr. Neman. We'll take Ms. Weedman after that.
Okay.
Your Honor, if I may ask, do you need Mr. Zarkin to say the plan was to plead, but the prosecutor would like to wait? Do you need him to say?
Hold on. I thought we already dealt with that one.
We did.
I didn't know if you wanted to.
No. Mr. Zarkin, have a great day. We'll see you next time.
Thank you, Judge.
Thank you, sir. All right, so now we're here with Mr. Neman. Sorry that we distracted a little bit from your file. Ms. Otel is here from the Michigan Department of Corrections.
Your Honor, Jesse Williams, I'm representing Mr. Neman for the record.
I know we have a sentencing today scheduled. I spoke earlier in chambers with Mr. Ringstrom. He informed me of a potential issue. I spoke with counsel here at the bench. Mr. Williams confirmed with the same issue. The defendant pled to operating while intoxicated as a third offense and carrying a concealed weapon while under the influence of alcohol. There was an agreement, a Killebrew agreement, that the defendant would be placed into the sobriety court program. In that instance, that if he was placed into that program, the case would be continued on a delay. If the defendant was successful with that delay, after a year, he would have the right to withdraw his plea from a third down to a second, which means from a felony down to a misdemeanor. And then continue in the sobriety court program as the case would be referred back down to the district court, which also handles the sobriety court program. Because the sobriety court program has found him to be ineligible, the question now being presented here to the court and the parties is, what do we do now? I'm told Mr. Ringstrom is going to amend the pretrial agreement. That amendment would be as for a delay under 771.1 parenthetical 2 that would be monitored by the court separate from the sobriety court program. Is that correct?
That is correct, Your Honor.
And why don't you tell me a little bit more about what you anticipate to be done during the delay?
What I would anticipate being done during the delay is all of these terms that are listed in the probation department and the probation report, along with Mr. Neman doing AA as mandatory as far as that goes as well. And it says counseling is directed, and speaking with Ms. Otel, she had indicated that she could make sure that there is additional counseling as part of the program.
Okay.
If you were to maintain his sobriety throughout that whole year and comply with all the probation, people would be okay with taking the offer down to the OWSI, let him withdraw his plea and go down to the OWSI.
In effect, Ms. Odell will monitor his conditions, not the sobriety court program, but he would then in effect get the same benefit.
Yes, Your Honor. Realistically, he would get all the benefits of the sobriety court program without the idea of the sobriety court because they declined it.
And as I understand it, this is to use air quotes, a true third, meaning he hasn't had a prior felony.
As far as I understood it, yes, it is a true third.
All right, good. Mr. Williams, does that sound like what you understand to be happening?
Your Honor, I've discussed this with my client. I think this would be a good opportunity for him. I would suggest perhaps he find a outpatient counselor and stick with that person during the entire period, because
I'm gonna make a condition that he follow what he and Miss Odell work out.
Oh, okay.
Copy that.
Thank you.
All right, Mr. Neman or Nyman?
Longy.
Was it?
Longy.
Longy. Neman. Thank you. Mr. Neman, please raise your right hand. Do you swear or affirm the information testimony about the body shall be the truth, whole truth, nothing but the truth?
Yes.
Thank you. You may lower your hand. Mr. Neman, you guys go and have a seat. Thank you very much. Mr. Neman, last time you were here, we entered a plea. That plea had certain conditions. Because of the sobriety court not accepting you into the program, I need to go over what the conditions are changing to. And I need to see if you accept them. Because right now, if I'm going to leave that decision out there for just a couple minutes. The question again is, do you withdraw your plea and have the case set for a trial? Well, we don't have to set it for a trial if you continue your plea with an understanding as to the changes in the terms or conditions, okay? Mm-hmm. So the agreement is now that instead of their Killebrew agreement, which would place you in the program, as I described earlier, you'd be pleading, you'd still be pleading as charged. And the agreement is that for sentencing, I would put you into a delay. A delay is technically not probation. However, the court is allowed to give you very similar terms and conditions of probation. And those terms or conditions are listed in this pre-sentence investigation report. Instead of being monitored by the sobriety court program, they're going to be monitored by Ms. Odell. It may include attendance of 12-step programs like AA or a program that she approves. And that's the key issue, that part of the key issue, she approves it, right? So if you want to go to a private counselor, which might be better, that'll be perfectly fine with me as long as she approves it. And I suspect she'll be quite flexible. Ms. Odell's been doing the job for a long enough time, and she knows different treatment programs work differently for different people. Now, this phrase I've used a couple of times, I discussed last time, and it's called Killebrew. Killebrew is an agreement that you make with the prosecutor about sentencing. There are a couple different kinds of agreements. Think of them as two different geometrical shapes. The first one is a line between you and him. I'm not a part of the shape yet. That's called a Killebrew agreement. You agree with him, and if I don't go along with it, you would have the right to withdraw your plea. The other is a triangle. It's called a Cobb's agreement, where we would all agree. Now, I typically do not do Cobb's agreements because when I take a plea, I don't have the benefit of a pre-sentence investigation report, and I never know if something's going to shock me when I get it. So I don't like to tie my hands until I get the report. I'm going to, in effect, make today the first and the only, and most likely the last, Cobb's agreement, because I'm going to tell you that if you continue this plea and accept the changes, I'm going to go with the recommendation. I was going to put you in the sobriety court, and since the prosecutor agrees and Ms. Odell is going to do a great job with you, I'm willing to accept it. You understand? Mm-hmm. Make sure you use words because Nancy's got to get words out. It's okay. It happens every day. So do you understand the terms of your agreement?
Yes.
And are you willing to accept those modified terms as I just discussed?
Yes.
And do you still wish to continue the guilty plea as previously set?
Yes, Your Honor.
The court reaffirms the finding of guilt, reaffirms that the finding, reaffirms the convictions as last discussed on the record, and reaffirms that the defendant's plea is made freely, knowingly, and voluntarily. And Ms. Otel, I think that would necessitate a charge or maybe some paragraph to modify the terms of the agreement. Understand? So now it's no longer a sobriety court program. I think you probably need to modify it that says, well, we were going to do sobriety court, but now we're going to do a delay.
I can add a PSI update.
That'd be perfect. That'd be great. Thank you very much. So now, Mr. Ringstrom, do you have any amendments, corrections, or objections to make to the contents of the pre-sentence investigation report?
I do not, Your Honor. There was only an issue with restitution.
Okay. But do you want is there restitution I need to add?
There was going to be
Typically, that's for you all.
$789 to Jacob Ferguson and $100 to Misaki Sharon.
No objection.
And $100?
$100 to Misaki Sheriff and the $789 for Jacob Ferguson.
Mr. Williams, any allocution?
Please, just a couple things. Although he is getting a great opportunity here, although he'll be accountable to the court and have to maintain his sobriety. One of the benefits that he cannot get, though, is the driving privileges, because it simply is not permissible. I'm just going to ask the court, because he's going to be doing equivalent to sobriety court without the ability for driving privileges, we're going to have to do that the old-fashioned way. If the court would consider reducing or not forcing the 180 hours of community service on top of the sobriety court request, on top of not having the license. That's my only request.
Thank you. Mr. Neman, is there anything you wish to say to me at this time before I give a sentence? You probably don't want to mess it up, so.
Right, yeah.
Sorry. No, I'm sorry. I'm not trying to dissuade you. I'm just telling you it's okay. All right, thank you. All right, the court sentences the defendant as follows. The court places the defendant upon a 12-month period of a delay pursuant to MCL 771.1 parenthetical 2. The terms and conditions of that delay will be those which are set forth in the PSI on CFJ 145 pages 2 and 3. I find that they are well suited for rehabilitative purposes. The only one that I think we need to change, however, is number 18, because there won't be a period of confinement because the sentence will be held in advance for that year period. Mr. Neman, again, make sure you follow those terms and conditions. And if you do, you'll get the benefit of the pretrial agreement. Now, one thing I forgot to cover. I think the delay only covers count 1, the operating while intoxicated third, correct?
Yes, Your Honor.
Correct?
That's accurate.
You understood that, Mr. Neman?
Yes.
All right. So then what I'll do is I'm going to set a 12-month period of probation for count 2, for which the same terms or conditions will apply. So you got the same set of orders. For the drinking and driving, we call it a delay. For count 2, we call it a probation. The court sentences the defendant to 2 days in jail and 2 days of credit. The court assesses a $68 state minimum fee for the felony, a $50 state minimum fee for the misdemeanor, $130 crime victims right fund fee, a $300 court cost, a $500 fine, and there is no attorney fee as Mr. Williams was retained. Supervision fees are $30 a month or $60 a month if there's any electronic monitoring. Did we have to do DNA here?
Yes, I believe we do.
I'm sorry, but was it already done? Because technically the felony, he hasn't, it's adjourned out. So I'm just saying, did we already, I'm asking the question, have we done it yet?
It does not look at according to my notes.
Did anybody take a swab of your cheek?
They did.
And did you pay a fee?
I did not because that's when I got arrested.
Okay. We'll make that a $60 DNA fee payable to the Wexford County Sheriff Department. There's also restitution in the amount of $798. And I don't know if, I assume this is a typo, but Miss Odell, you called it 103 cents. I don't think we can do that. So I'm just gonna say $798. Payable to
I apologize for interrupting. Where are you seeing that?
one CFJ 145, page 3. By the way, you had $0 on page 1, so I'm just gonna go with $798 payable to Mr. Jacob Ferguson. And then $100 payable to, is that's your prosecutor fee, or is that the Sheriff Department?
Sheriff's Department.
Payable to the Missaukee County Sheriff Department. All right, anything else that I've missed, Ms. Odell?
No, Your Honor, thank you.
Mr. Ringstrom?
No, Your Honor.
Mr. Williams?
Thank you.
Because the felony conviction is not yet permanent, we'll be back here in a year. I don't need to go over his appellate rights. He only has, the final conviction only applies as to the weapons. Any weapon is forfeited, which is already done by statute. Make sure you're compliant with your terms or conditions, all right? I don't think I have anything else. Thank you very much, Roger. All right, our next case back up here on the docket is People versus Christy Weedman. And file number is still 25-3628FH. Court recognizes the same parties that were here earlier this morning, as well as Miss Odell, although she may not have anything to do with the case yet. Anyways, what are we doing now? Ms. Fioravento?
I think, Your Honor, my client would like to accept the people's plea and we're prepared to go forward on the record.
All right, Mr. Ringstrom, tell me what the agreement is.
The agreement is that Ms. Weidman will wind up pleading guilty to count 1, possession of meth as a second subsequent. People will dismiss the half court.
Thank you. All right, Ashley, you're making some grumblings over there. Everything all right?
Let me give you the figures.
Mr. Weiss, we'll be back with you in just a minute. Don't go anywhere. All right, we're running a bit behind, but that always happens. All right. Here we go. Ms. Fioravento, is that a complete and accurate statement of the pretrial agreement?
Yes, Your Honor, and I appreciate the court giving me additional time to discuss this offer with my client. Thank you.
And no problem. Did you say pleading as a second sub or a second half?
Second sub.
All right, thank you. Ms. Weedman, is that how you wish to resolve this case?
Yes, sir.
Please raise your right hand to the best that you can. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes, sir.
Thank you, ma'am. You made a lawyer hand. Ms. Weedman, looking back on July 4th of this year, were you on probation, parole, or bond?
No, sir.
All right, and make sure everything you tell me today is the truth. I anticipate that it will be. I just, sometimes we get people who like to claim that the meth was actually somebody else's. So, you are currently charged in a felony information with a single count. That count is possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Now, there are 2 potential sentencing enhancements. I'm told you're going to plead guilty to one of those, and the other one will be dismissed. The first of those is as a second or subsequent drug offender. That has the ability, within the discretion of the court, to increase that maximum punishment from up to 10 years to up to 20, and from up to $15,000 up to $30,000. In the alternative, you could have been sentenced as a 4th habitual felony offender. That could have increased that maximum punishment from up to 10 years to up to life. However, if you plead guilty of possession of meth as a second or subsequent offender, the prosecutor will dismiss the 4th habitual enhancement. Is that what you understood?
Yes, sir.
Now, by pleading guilty, if I accept that plea, you will not have a trial of any kind. You'll be waiving certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose and the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have it silence used against you, and the right to testify if you chose to testify. Ms. Weedman, do you understand those rights?
Yes, sir.
And more importantly, do you understand that if you plead guilty and I accept that plea, you will be waiving those rights? Thank you. Furthermore, any appeal as to the sentence and the pretrial agreement would be by filing an application for leave to appeal and not an automatic or claimable appeal by right, which is only guaranteed when you are convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements other than the pretrial agreement to get you to plead guilty?
No, sir.
Now, are you entering the plea of your own free choice?
Yes, sir.
Now, Ms. Fiorvento has probably gone over the sentencing guidelines and try to give you an idea or estimate as to what she thinks you may receive for a sentence or how you might score on those guidelines. I highlight for you that the guidelines are not mandatory. They are a useful tool for the court to help establish a reasonable and proportionate sentence. Also, her suggestions might not be right. In other words, it's only an estimate. It's her best educated guess based upon her experience here as an attorney, but also before this court. Has anyone made any promises to you as to exactly what the sentence would be?
No, sir.
Do you still wish to enter the plea of guilty as we discussed earlier?
Yes, sir.
Thank you. As to count one, how do you plead?
Guilty.
As to being a second or subsequent drug offender, how do you plead?
Guilty.
Looking back on July 4th of 2025 out in Riverside Township here in Missaukee County, what happened that makes you guilty of this offense? Did you get caught with some methamphetamine?
Yes, sir.
Where were you when you got caught?
I was leaving the fireworks with my daughter.
Okay. And what happened? How did you get caught with it?
I got pulled over because I got recognized for a warrant I didn't know I had in Missaukee County or Wexford County.
So a law enforcement officer exercising a warrant apprehended you, and then they did a search. Where was the methamphetamine found?
In the backpack that was in the front.
And were you the driver of the car?
Yes, sir.
And was anyone else in that front seat?
My daughter.
And was this your backpack?
Yes, sir.
And did you know the methamphetamine was there?
Yes, sir.
And how was it contained?
Inside of a bag, inside of a cigarette pack.
Okay, and so if you were to pull out that little baggie, could you actually see the crystalline substance methamphetamine inside that baggie?
Yes, sir.
And so you knew that it was there, is that right?
Yes, sir.
And did you also know that it was methamphetamine?
Yes, sir.
And you agree that you had no lawful right to possess that methamphetamine? And is it also true that on or about April 27th of 2018, you were convicted of maintaining a drug house?
Yes, sir.
All right, thank you. Mr. Ringstrom, do you believe she provided a factual basis?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements?
I am not.
And do you believe the court complies with Scroll 6.202?
I do.
Ms. Fiorvento, do you agree?
Yes, Your Honor.
The court agrees and finds the defendant's plea is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for count one, as well as the second habitual enhancement. Therefore, she is found guilty as such, and the fourth habitual felony enhancement will be dismissed at the time of sentencing. Ms. Weedman, we should be back here in about a month for sentencing. Between now and then, an agent from the Department of Corrections, such as Ms. Otel, will prepare a pre-sentence investigation report. That report will describe the pretrial agreement, the facts of what happened, information about you, prior criminal history information, how you performed on probation in the past, and make a recommendation as a sentence and include a scoring of the guidelines. I highlight for you that a recommendation is merely that, and the guidelines are just merely a suggestion. They are not mandatory. It's up to the court. You're going to get a packet of information there at the jail. You're going to complete it and turn it in. You also will be subject to an interview with an agent from that office, such as Ms. Odell or Mr. Blazak. You have the right to have your attorney present during that interview. And lastly, Ms. Firavento, once she gets that report, which is generally about 10 days to 2 weeks before sentencing, she's going to go over it with you. And it's very important that you all make sure the information is complete and accurate to the best that you all can. All right. Do you have any questions about what we've done today?
No, sir.
The court revokes bond, remands the defendant to custody of the Missaukee County Jail. Anything further today, Mr. Mr. Veto?
I think, Your Honor, on the bond issue, we would actually request that if my client could attend rehab, if she's able to secure rehab. I
You
know
guys
she's previous.
If you get it, let me not peer into the crystal ball. You all get it and you all agree, you come and let me know.
Okay.
All right, then we'll deal with it at that time. Probably put together a stick, put all the information that you all know I want to see. Thank you very much.
Thank you, Your Honor. Thank you.
You're adjourned. Now that takes us all the way down to our final pretrial conferences. And I know we have a pretrial meeting soon. Let's see if we can knock out that pretrial first. And that is, apologize,
DeCoco, Your Honor.
DeCoco. All right, is Mr. Bardish on there? M. Bardish?
And that's maybe
He
an
has-
iPhone 5.
He has another attorney that's stepping in his place for today. I don't remember what his name is though.
We'll try this one and
What,
see.
just read the names for me and I can tell you.
Well, there's Nate,
Ringstead?
Nate Pepper.
Okay.
There's another one, but I know she is for Jacob.
Yeah, just bring one in. Let's see what it is.
So we're gonna
Might be
see
that.
who the iPhone 5 is.
Yeah,
iPhone 5 is me.
that's Bob, Mr.
Okay.
Champion. All right, so go with
Not
me.
you.
So before the court, we have Mr. DeCoco, and also before the court, we have Mr. David Denhout, Missaukee County Prosecutor. And we are waiting for the mystery defense attorney covering for Mr. Mike Bardish.
So maybe it's this Nate.
Okay. We're here today for a pretrial conference. Mr. DeCoco, that's an opportunity for the parties to tell me what's going on. All right, that's Mr. Now, that's, you just aged yourself because that means you don't know Pfeiffer. Yes,
Okay.
that's because you don't know the history of the family and the connection to Hemingway, which, by the way, had a cottage up on Walden Lake, blah, blah, blah. Anyways, Mr. Nate Pfeiffer, sir, are you here on behalf of Mr. Bardish?
I am, yes, Your Honor.
All right. Tell Mr. Bardish that the judge was extremely angry that he could not appear today. Mr. DeCoco, that's the judge. All right, do we have any resolution of the case today, Mr. Denhout?
Your Honor, we do not today. I have been regularly having conversations, discussions with defense attorney Bardish. I think that the intent by the parties is to, at some point, have a discussion, set up for a separate date and have a discussion with Your Honor. There is some plea negotiations. I won't get into them at this point, but I think that that was the intent of the parties, that at some point we would discuss, or we would schedule an individual meeting time at the future to discuss possible resolution.
All right, so we have no resolution this time. Mr. Pfeiffer, do you know if there are any discovery issues In other words, are you getting everything? Are there anything that you're having trouble with?
Yeah, there are no issues on that end, Your Honor. The prosecutor is correct. Mr. Bartish just indicated to me that the plan for today was to schedule a meeting with Your Honor to discuss some things about the case.
All right. So our next scheduled appointment here in this case is for a final pretrial conference that is currently set for October 6th. If you all wish to get in with me earlier, whether it's via Mr. Bartish and Mr. Denhouten via Zoom, we can do that. You all just have to arrange it with the office. Mr. DeCoco, Mr. Denhouten knows this. Mr. Pfeiffer may not. Mr. Bartish should. And a final pretrial conference. That's the last conference before the case is set for a trial. The trials are typically set within about 10 days after that. On that date for a final pretrial, if your case ends up being the oldest, in other words, the last one set for that trial date, then that is the last date I will accept a plea, or we're going to trial. Now, that is never a pressure on or intended to be pressure on the defendant. I don't care what you choose. I don't know anything about you. I don't know anything about the case other than the charges that I see. I've got no idea what the quality of the evidence is, so I don't have any dog in the fight. The reason why I have that policy is to put the pressure on the attorneys to exhaust all of their arm wrestling and negotiating skills. Because what I don't like, and I don't let happen, is that whole thought, well, I bet if we show up on the day of trial, the deal will get better. Nope, I want the best deal given on that date. Now, by the way, I don't even know if a pretrial agreement is appropriate. I have no opinion about it. But the position here is to make your attorneys do their best job. Okay? All right, thank you. Any questions about what we've done today?
No, Your Honor.
All right, Mr. Pfeiffer, anything else?
Nothing further, Your Honor.
Mr. Denhouten.
No, Your Honor. Thank you.
Make sure you're compliant with your terms and conditions of bond. We are adjourned.
Thank you again, Your Honor.
Thank you. All right, our next file today is this Ms. Bloss? No.
Jacobson.
Jacobson. People of the State of Michigan versus Tiffany Jacobson. This is file number 25-3606FH. Do you have a Lisa Satawa? Kirsch Satawa. Court recognizes Mr. Bruce Ringstrom. Sorry, I did it. Gosh darn it, I haven't done it in like 2 years. Robert Ringstrom. Bruce was his brother. I went to high school and junior high and middle school. Disregard. Here in the courtroom is the defendant, Ms. Tiffany Jacobson, and also join us via Zoom, hopefully while not driving down the road.
I'm going to pull over.
All right.
I have on my way to court, though.
It's okay. As long as we don't have a record of you driving while using your phone. I'm going to turn away for a moment. Pretend I don't see it. Or I'm going to hope that she's in another state. That's what it is. All right, Mr. Ringstrom, do you know if we have a resolution today?
I do not believe we have a resolution today. I am not sure. I know defendant just got a recent new attorney.
Okay. Ms. Satawa, are you new on the case?
I am. I was just appointed late yesterday afternoon. I did speak to Nicole Smith, the former attorney, and I'm going to meet with her on Sunday to get the discovery and whatever else she has. I haven't had to meet my client yet. So if the court would adjourn this for a couple of weeks just to let me catch up, I'd appreciate it.
All right. The court will adjourn the file. I do know that I think we had discussion before. I understand why Ms. Smith needed to withdraw from the case. We appointed new counsel. So I think that's fair. Any objection, Mr. Brinkstrom?
There is no objections. Just for the record, we did also file a motion to consolidate this trial along with one of them with Miss Molly White. Now that we know who the attorney is, we'll make sure that we get that over there as well.
All right, so I see that motion to consolidate. Now that we have new counsel, I'm going to direct Mr. Ringstrom, since it's your motion, if you could set it for a hearing now that Ms. Otel was involved.
Yes, Your
All
Honor.
right, thank you.
Was going to set it for a hearing while I was getting it filed was when the other attorney was withdrawn.
Got it. Okay. All right, anything else, Mr. Ringstrom?
So the trial is going to be rescheduled also.
Yeah, the trial will also be rescheduled, of course. Ms. Jacobson, do you have any questions for me?
No, I don't.
Today is just a pretrial conference. Typically, it would be a final pretrial conference where the case would be going to trial in about 10 days to 2 weeks. But because you've got new counsel, which is no fault of your own or even fault of your prior counsel, we want to make sure that she has the opportunity to be caught up to speed.
Okay.
All right. Now there's a request to consolidate your case with another case, and that is with the defendant Molly White, who I think is coming up next. I haven't ruled on that yet, so I don't know. All right. Ms. Kirsatella, thank you very much, and we look forward to seeing you up here in Missaukee County.
Nice. Thank you. Nice to see you too, Judge.
Nice to see you. Thank you. We're adjourned.
Thank you.
Right. All right, hold on. I'm still going through notes. Let's see. Now where are we at?
Hold on.
All right, let's take care of Mr. Weiss. He's been sitting there on Zoom. People versus.
He wanted to meet with Champion.
Oh, he still wants to meet with Champion. Mr. Weiss, can you see and hear me?
Yes, sir.
All right. Mr. Champion is wandering in and out of the door, but he's going to go out the hallway, dial in.
Okay.
We'll move into a breakout room. Stand fast. We are in recess on Mr. Weiss. Now we're going to take people in the state of Michigan versus Molly White. Case numbers are 25-3614 and 3619 FH. Appearances.
Thank you very much, Your Honor. Attorney Robert Rich, Assistant Prosecutor for Missaukee County.
James Dick on behalf of Miss White.
Miss White is currently in pretrial custody and she is being brought forward. Courtroom, one moment. We're here for a final pre-trial conference. I know that there's another case that we just dealt with, and that is People versus Tiffany Jacobson, in which the people have requested to consolidate one of these files with that of Miss Jacobson. In that would be file 3614. But we're going to postpone that and let's see what we're doing. Do we have any resolution to either one of the two cases?
I do not believe so.
No, Your Honor. Thank you. All right, Mr. Ringstrom. That means that we are able to go to trial on 3614.
3614 would be the file that we filed a motion to.
3619.
So 3619 would be the one that would be stuck.
Thank you very much. Yes, sir.
Your Honor, I did file a motion this morning asking, motion to adjourn the trial date. And, bring it back.
Sure. Let me see it.
That's actually have one first.
And we're talking 36.
I have
19.
1, 4, and 3619. I'm sure one of them would have been
3614 is adjourned. You know that.
Sure.
So I'm going to make a note. 3614 is adjourned because we have a motion to consolidate with the People versus Tiffany Jacobson, 3606. Now let's take a look here at the motion to adjourn the trial date. All right, I'm thumbing through the file looking for some information, and I've come across the prosecutor's objection to the defendant's second discovery request. Was that ever set for a hearing? That was filed there on June 23rd.
It was never set for a hearing, Your Honor.
Okay.
At the time, the objection in there informed Mr. Dick that if he had any specific objections going forward, we can go and argue this motion, but he has not said anything about the discovery.
All right, I don't need to address anything there.
There is, I assume the court had noticed there should be a prosecutor's motion to quash its name on defendant's witness list.
Yeah, I got that. We'll deal with that in just a second. Okay. All right. So I'm going to take a moment here as I continue to review the defendant's motion to adjourn the trial date. Actually, you know what's going on with the transcript? We dealt with this a little while ago with the person who left and said they were going to do it, but of course failed to do it and never did it. You know whether or not Linda was supposed to assign
I don't
those
know
to somebody
who
else.
got hers. I know I got quite a few of them yesterday.
All right. We'll look into the transcript for this one.
Your Honor.
Yeah, yeah.
I did speak with Heather in the district court office this morning, and I guess she has been assigned.
Oh, okay. And then she has been assigned. All right.
Okay.
All right. So thank you. All right. And so what, besides just getting the transcript for testimony and cross-examination, is there some other reason, any other motion that would come out of the transcript? Did you handle the preliminary exam?
I did, Your Honor.
Okay.
Yes.
So is there something in there that you think is necessary for a motion?
So the only other thing, your scheduling order, Your Honor, says that the witness list has to be filed at least 28 days before the trial date, and only it can be amended with the court. So there's potentially additional witnesses that might have been mentioned in there that I don't have their names at the present.
Okay.
So I would need that to add.
All right. Well, that I can always do a workaround and get you a recording of it and allow you to have access to that while they're still preparing the transcript. All right, so the next question here is, there's something here, you're requesting to complete DNA testing of evidence. What evidence needs to be tested for DNA?
So, Your Honor, the DNA evidence would be a urine sample.
Okay. And she's got a charge here of possession.
Yes.
So was there, hold on a second, Mr. Richter, why don't you tell me what the nature of the possession is?
For this file, actually, we have her on delivery of, not to be on, controls of delivery.
Okay, hold on. I thought I was looking at. Oh, that's 319. That one, I should just keep this over. Yep, okay. I was looking at the wrong one. All right. So we've got a delivery, an R&O, and contraband into the jail, and then a tampering with evidence. So where does urine come in? Is the allegation that she swallowed it and then that's why you need pee?
The allegations would consist of, I believe, I don't want to speak for Mr. Dick, but I believe where he is coming from is urine samples that were taken from other inmates in the jail that had said that she had delivered meth to her. There was a urine sample that was done. I don't think that we have any more urine samples. I'm not exactly sure which he's talking about as far as it goes, because we had a blood draw.
So what urine samples?
So they would have been the initial drug test at the jail, Your Honor.
So do you know if they kept the urine?
I'm not 100% sure at this point in time, Your Honor. I was going to ask the court.
I do not believe they kept it,
Your Honor. So
So do the people intend to offer any evidence of urine tests?
No, Your Honor, we do not.
Are there blood tests from these individuals?
There was blood tests that were done, a blood draw was done at the hospital, and then they were there. We had it tested, and I'm trying to come up with a chain of custody. I thought that they destroyed it afterwards, but I'm not sure.
Hold on. Let me see if I can catch this correctly. The alleged delivery occurred allegedly in the jail.
Yes.
And some of the witnesses that the people have listed must be the other inmates.
Yes, sir.
And those other inmates may have tested positive for methamphetamine, correct?
Yes, sir.
And that would be used to corroborate whether or not they did or didn't, or whatever their testimony is, whether or not they received it from the defendant allegedly.
Yes, sir.
Okay, and so was there P tests done?
Originally, my understanding was there were P tests that were done, but based off of the P tests, they wound up going to get the blood samples.
So it's the same thing as a preliminary breath test. So they then went and got a blood draw, and those blood draws allegedly report that they had methamphetamine or didn't have it in their system.
Yes,
either one of the two. All right.
Yes,
So
I can make the connection.
yeah, go ahead.
Your Honor, so the one of the allegations that kind of sparked this whole issue was that there was urine given by one of the inmates to my client to like circumvent a drug test.
Right.
The drug test that was taken came back dirty.
Okay.
And the urine sample, if we were,
was it the urine sample from her allegedly?
The alleged urine sample.
So someone else in the jail allegedly gave her urine that she could use to circumvent the test.
Yes, Your Honor.
And that alleged urine was tested positive anyways, right?
Yes, Your Honor. That's
okay.
That's
so. All right. So you want to determine the DNA of this urine.
Yes.
Of that urine, not the other urine.
And the unit, the small bottle that's in, I believe is labeled present People's Exhibit 4, that had the means of giving the urine to my client.
Is she charged with testing positive?
No, Your Honor. However,
okay.
If this urine that tested positive is the same urine that was in this bottle, it would provide at least some reasonable doubt that my client had supplied.
How does it apply reasonable doubt? If that witness, do you know who gave her, do you know who allegedly gave her the urine?
Yes.
All right. So you can ask that person if they gave her the urine.
Yes.
And do we know what have they been asked that question?
Yes.
And do they admit it?
Yes. However.
Okay.
They also had said that they had never tested positive or should not have tested positive because they hadn't taken anything before receiving the methamphetamine from my client. So,
and is that person one of the ones that claims she delivered it to?
Yes, John.
Okay. All right.
And if the DNA, if we're able to obtain the original P sample and compare that DNA to what was in the little bottle, that if they match, that would also be compared against my client's DNA, which would show that the positive test was not her. So that would demonstrate.
But she's not charged with testing positive.
Right. So the timeline of everything suggests that the urine was provided before the urine, the fake urine or urine that was provided to circumvent the drug testing was provided before the methamphetamine was given. Now, if that urine actually tested positive, then that person likely or must have had the methamphetamine before she gave the urine sample to my client.
Before what?
Before
you got to stop talking proper. You got to figure out your argument, because I don't think you even know your argument. So she tests positive for urine using someone else's pee, and they obviously had used methamphetamine, therefore it caused them to test positive. But they have somehow said they never tested positive.
They said that they couldn't have tested positive at the time they gave my client the urine.
Okay, but does that person now testify that she gave them methamphetamine at some time?
Yes, Your Honor. If I may try and clear up the facts, what is, I believe Mr. Dick is arguing is we have a situation where one of the inmates admits that Miss White had wound up giving her urine. She admitted that she gave Miss White urine in a plastic bottle. And that's what I think Mr. Dick is talking about, is this plastic bottle. That tests did allegedly come back positive for meth, which Molly White claims.
How was it tested? In a lab or with the dipstick?
It was just tested at jail. It was just tested at the jail. So what Mr. Dick is saying is he wants it tested to be able to show that maybe it's the other inmates' DNA that's in that bottle that supposedly tested positive. The other inmate definitely did admit that she wound up putting the urine in the bottle for Molly White, but had indicated that she has no idea how that could have come back positive because she had not used beforehand.
Okay.
I don't know where the DNA
but
comes
she's
in.
not, but Miss White isn't charged at all with anything about the urine bottle.
No. I believe what Mr. Dick is trying to argue is that the other inmate would have been tested positive for meth before acknowledging she was in receipt.
So in other words, the pee tested positive for meth that she got from somebody else other than her.
Prior to that, yes.
Okay. Because she couldn't have gotten meth from any other person. And did you find out how long she'd been in jail? Had she been in jail without a period of time for it to clear her system?
Well, I believe she had been in custody since sometime.
You gotta stop this believing and putting together a timeline that you can't put together and try to explain it. So let's skip back to the very first question. Is there any urine to go test?
I do not believe that there would be any urine to be able to test. I think Mr. Dick is trying to argue he wants DNA testing on a plastic bottle that was used.
Is the bottle still here?
Yes.
Okay. So we're not testing urine, we're testing for remnants of DNA inside that particular bottle. Okay.
If the urine samples are available, Your Honor, I was seeking to obtain at this time. And I don't know 100% that they are or not, but
or not what?
That they are still available, or if they are not still available.
He said they are.
The bottle is, I know the bottle is, as far as the urine sample goes, Your Honor, this is the first time I've ever been requested as far as the urine samples go. I did not check. I'm pretty sure they destroyed them and got rid of them. If it does matter, I could go back and check with the jail right now as far as everything.
You all can set this for a hearing, and you're gonna set it sometime next week.
Okay.
This is a motion that has nothing to do with the transcript. Should have been brought up a long time ago. And I'm gonna tell you, you better in your motion, or if you want to redo yours, you better give me a timeline that tells me when all these people were inside the jail. In other words, all the people that allege that they got the substance from her. When did they get to jail? How long have they been sitting there? When were their last, did they have any other blood tests or urine tests? I mean, you got to figure all that out. This argument is put together like, I don't know, you can grabbing a handful of sand and dropping it on a plate. It's guessing, and you shouldn't be guessing at this stage. So I'm not going to adjourn the trial until I have a motion or give me a reason for it. So far, I don't have necessarily a reason for it. Plus, this is not set for a hearing today. So you guys can deal with that, file it and get it on the docket. All right, so now I've got to deal with Mr. Ringstrom. We have to deal with Mr. Ringstrom's motion. Mr. Ringstrom, you were listed on a witness list in file 3619. That's the same file we were just talking about. Is that right?
I was also listed on the other file as well, Your Honor.
All right. Why is he listed on as a witness?
It was because of something that happened during the preliminary exam, Your Honor.
What happened during the prelim?
I had told a witness that the people had subpoenaed to testify on our behalf. And,
okay.
Mr. Ringstrom kind of lost his cool and told the witness that if he testifies for the defense, he will revoke his immunity. And the reason that he's on both of those is that, again, I don't have the transcript because I need that for.
Is this done on the record?
Yes.
Okay. Is there Mr. Ringstrom, before you put a witness on the stand, did he make a statement?
The witness had made a statement through a police report.
Gotcha, that's what I expect. So during the prelim, did he start to change his story or something, or not testify consistently?
As far as I know, no, he was going to testify consistently as to what his police report was.
So what is the issue with him saying if he doesn't testify according to his statement?
No, the statement that Mr. Ringstrom made was if you testify for the defense.
Okay, so how does that make him a necessary witness? Is he going to testify?
I don't know, Your Honor, if he is or isn't.
How do you not know if a witness is going to testify in a case that you're set for trial in less than 2 weeks? How do you not know? You should have talked to him.
Oh, I spoke to him.
Okay.
Like ultimately, I don't know what he is going to do at trial. I don't know if he's going to plead the fifth, which
well, he can't. Did I grant him immunity?
No, he was not granted immunity, Your Honor.
Oh,
and this
okay.
is dealing with the file of the 3614. It's not even this file 3619.
And I'll get to
what had happened is, if the court wants me.
Yeah, go for it.
What happened was we had.
By the way, this happens a lot. I know defense attorneys do it. They always do it when they've been practicing for about 4 or 5 years, or somewhere less than that. They always throw the attorney on the prosecutor, and almost never, ever does it ever happen. Go ahead and explain it to me.
So we had 4 witnesses that we were prepared to go and call in at the prelim. 2 of them needed use immunity to be able to testify. After the 3rd witness, in 2.5 hours of a preliminary exam, prosecution decided not to call the other witness that we were going to give use immunity to.
Okay, who is that witness? Give me
it was Mr. Ohm at the time. Right. So then Mr. Dick decided he wanted to call Mr. Ohm as his witness.
At the prelim.
At the prelim.
Okay.
And there was some discussion. I don't remember the specific words, obviously, with the transcript or whatever, but there was some discussion as far as me saying that if he's testifying for the defense, he's not got our use immunity because we were the ones who were using it at that time.
All right.
And then after more discussion, I just agreed I would call him as a witness, but the court at that point in time had indicated that they just wanted to go forward.
All right.
I have no
Mr.
idea.
Dick, what's your version of that? Because that's a little bit different than what I heard. So tell me what happened.
So at this hearing, yes, there were 2 deputies and another witness who had been granted immunity had testified. And Mr. Ringstrom declines to call the other witness. Based on my prior discussion, we thought there might be.
You said he decided not to?
Pardon?
You said Mr. Ringstrom decided not to call that witness, Mr.
Yes,
Owen?
sir.
All right, copy.
And I ended up calling him.
Okay.
And Mr. Ringstrom kind of blew up initially about that and said that if you testify for the defense, I'm revoking your immunity. And part of not having the transcript today is we're relying on this as the offer of proof. And it may be better to address everything with that. But I did speak with this witness, and I do not ultimately know if he's going to testify or plead the fifth or what he's going to do here. So at the
you got to spit it out, man.
Sorry. At the same time, we were.
You may as well say every other word. You're not doing but I cannot follow when you're talking. So just keep going. Let's see what you get.
At the time of the preliminary exam, there was again, I'm saying I believe, Your Honor, because I do not have the record or the transcript of the record. There.
All right, so let's.
Yes.
There was a signed order for use immunity that was in the file, and it dealt with Mr. Owen. That order says, is in response to a motion for immunity, or an application for use immunity. By the way, there we go. It's in the file, but it's not even signed by the judge.
It's not because he did not testify, so therefore the judge did not sign it. The judge was going to have him come up if I were to call him to sign the use of it.
Yeah. So hold on. It may have caught the prosecution off guard, but he didn't have immunity. And then what you run the risk of doing is pulling a witness on the stand that you might know is going to invoke the Fifth Amendment right. And you would have to then get immunity. So if he chose not to call the witness and the judge didn't give immunity, and if he's telling the witness, hey, by the way, I didn't call you, which means you don't get immunity yet. All he did was the right thing by telling the witness, hey, you don't have immunity. Be careful of what you say. He did the right thing. Now, if he testifies and you all want to get him immunity, fine. But how is that even relevant? Let's do it that way. How is what he said to Mr. Owen relevant? Because you don't know if he's going to test. Are you going to call him, right?
That's the intent.
Okay, Mr. Ringstrom, are you going to call him?
I would probably want to call him if there was a trial, yes.
All right, so you're going to want an order of immunity.
I would give him the use of immunity, yes.
Okay. And then he's going to put the witness on the stand. The witness is going to say A, B, and C. Then you're going to get up and you're going to either challenge him and say, well, that's not what you told the other people or whatever. That's fine. That's prior inconsistent statements. Got that. Then you're going to challenge him to say, what? His credibility because of what he said to him?
No.
All right. How would you use this? How is it relevant under 401? How is it relevant to make a element of defense more or less probable?
Well, it would make it more or less probable that Mr. Owen was threatened or felt threatened by the statement.
How do you know if he felt threatened?
Right.
But what does that matter? How does that go against his credibility?
Well, it weighs against his credibility because it actually has an influence now of how he is testifying, or if he chooses not to testify.
If I give him an order of immunity, he can't choose not to.
Understood.
So there goes that one. So then the question is does he testify consistent with what he had to say before? John, did he testify at the prelim at all?
No.
No?
He did
All
not
right.
testify.
So, all right. How is the prosecutor a necessary witness?
Well,
he's not. You were there.
Yes.
There you go. Maybe you need to be the necessary witness. Or Ms. White, but she has the right to remain silent, or the court reporter, or the judge before whom it was taking place. So the answer is you don't need Mr. Ringstrom. You have a transcript. We'll have a transcript by that date. You will strike Mr. By the way, why was Mr. Ringstrom on the other file then?
There, again, I'm saying this because I don't have the transcript, but I believe that one of the key witnesses in his other case, their mother was sitting in the courtroom here when that was said.
Okay.
And because I construed what he said as a threat rather than a warning, I believe that they would perhaps as well.
Did you talk to her?
No.
No, you don't even have the facts for the motion. He's not a necessary witness. You haven't talked to her. Boom, there goes that one. You don't know what she's going to say. You don't need the preliminary exam transcript to figure this out. This is very, very simple. You will get the transcript. I'm going to expedite it and I'll get it to you by the middle of next week. And if I have to work with a court reporter or a different court reporter to get it done, we'll get it done. Now, as for that, you're also going to set the other part for a hearing. And you're going to explain to me a lot better than anybody has done today as to how it's relevant to have a test of DNA of pee into a bottle. Sounds like at best you're going to say that one, the person lied and didn't know how it should have tested positive, or two, that she peed into that cup before the time and date which she says she received the methamphetamine from, allegedly, Miss White. Now, did that same person get tested again after that person pointed the finger to Miss White? That's important to know.
I'm trying to understand, Your Honor, basically what it is that person wound up giving to Miss White the pee.
Yep, I got it.
That tested positive.
Yep.
Molly White had accused her of giving her dirty pee. She said, I couldn't give you dirty pee. And then that person, after that, I believe was given the meth because.
So right, I got it. So then did she get tested after?
She got tested after her saying that Molly White had given her the meth.
Okay, and then she tested positive with blood draw.
Positive.
Okay, so we don't have any report that said, right, that urine was not tested at a lab.
No, that urine was not tested at a lab. That urine was tested through the gym.
Got it. So now what you're requesting is something else. What do you think you're requesting now?
Well,
if I were, I hate to say this is tough because these motions are kind of tough because I end up telling you all what I think you're missing. And I tell you what I would do. No, that's the problem. But here's what I would hold your feet to the fire on. What are the nanogram levels? That's what you want tested. The DNA is not necessarily the information you're looking for. That might be to help tie it to the person who says, yes, that was my P. But you're looking at nanogram levels, because if the nanogram level in that blood, and if that blood was done a week later or 2 weeks later from the whole P fiasco, there goes that argument. So you all put this together a lot better than you did today. We'll deal with that then. As of right now, the case it remains on the trial docket. All right. And so far, I'm going to strike Mr. Ringstrom as a witness, but he is not a necessary witness. If, for instance, let's say Mr. Ringstrom had talked to a witness, Mr. Ringstrom, if he was the only one present, now he's a necessary witness. If he does it with a law enforcement officer, he's no longer necessary. You can call the law enforcement officer. So here you had a room of people. He's not a necessary witness. If she feels intimidated, that's a question you can ask her. Did you feel intimidated? But then he's going to put out a transcript of whatever was said or a recording and play the recording, and then the jury's going to make a determination if that was reasonably to feel intimidated. I'm going to tell you, often you end up putting the word intimidated in people's mouths. But because I deal with that a lot when I deal with personal protection orders. I was harassed. Well, what do you mean by harassed? And they tell me, I'm like, well, that's not the definition of harassment in the law. Anyways, you guys can set this for a motion. I'm going to go find somebody to put this thing in the transcript request line ASAP. All right. So we have nothing resolved today. This case, 3619 goes to trial unless we make a change next week. I'm getting tired of adjourning trial. So, all right.
Your Honor, this trial was set for 2 days based off of the preliminary exam, the length of the preliminary exam, and the witnesses. I think that we probably are going to need 3 days.
When is it? Is it set for trial the following week?
It's set for trial September 8th.
Tonight. Yeah. All right. So we got a couple weeks. Yeah. At least 3 weeks, almost 2.5, 3 weeks. Oh, we got plenty of time.
We do.
Oh my gosh. Yes.
People are ready for trial.
All right. Thank you very much. All right, did you get all the way down to the bottom? Miss Bloss.
Your Honor, I'm going to ask for an adjournment. Miss Bloss, it's an exam to meet with her, and she's currently housed in Emmett County.
Okay, hold on. So we're going to take up this file, people in the state of Michigan versus Andrea Bloss. This is file 25-3607. Oh, wait, do we have Mr. Weiss?
We do have Mr. Weiss. He's in question. I mean, he's in treatment.
That's the guy we saw earlier?
Yeah, he's in.
All right.
He's going to be enter a plea today.
The what?
Mr. Weiss is going to enter a plea today.
All right. So Miss Bloss, she is not present. Where's she at?
Emmett County.
Jail?
Correct. She's on a parole hold. She won't be released except to be transported to. She was picked up yesterday and they weren't able to go out and get her today. For today.
All right, we'll adjourn that. I'm going to see if my staff can get her on a writ from Zoom next week. We're adjourned. Next file, and last file this morning, People of the State of Michigan versus Derek Weiss. File numbers 25-3611FH. Appearances, please.
Robert
Champion appearing on behalf of Mr. Wise.
Mr. Weiss should be joining us here in a moment via Zoom. And there's Mr. Weiss. All right, and we're here today for a final pretrial conference. Parties have informed me that we have a resolution. Mr. Denon.
Thank you, Your Honor. It's my understanding that Mr. Wise will be accepting the people's offer, which is to plead guilty to count 1, larceny in a building. In exchange, count 2 and the habitual 4th notice will be dismissed at the time of sentence, Your Honor.
Mr. Champion?
That is a correct statement of the plea agreement, Your Honor.
Mr. Weiss, is that how you wish to resolve today's file?
Yeah, I can't hear you guys very good.
All right, Mr. Weiss, how about there? If I speak a little bit louder, does that make it better?
Yeah, I can make it work.
All right, thank you. Mr. Weiss, I'm told today you're going to enter a plea of guilty to one of these counts. Is that what you understand you're doing?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Mr. Wise, you are currently charged with 2 counts. Count 1 is larceny in a building. That is a felony punishable by up to 4 years and or up to $5,000. I'm told that you will plead guilty to that count. Now, there's also a 4th habitual felony offender enhancement that could, within the discretion of the court, increase that maximum punishment from up to 4 years to up to 15 years. However, if you plead guilty to count 1 and the court accepts that plea, that 4th habitual enhancement will be dismissed. You are also charged with count 2, receiving and concealing stolen property of a value of at least $200, but less than $1,000. That is a misdemeanor punishable by up to 1 year and or up to $2,000 or 3 times the value of the property, whichever is greater. Again, that count will be dismissed. So far, Mr. Weiss, is that what you understood to be the terms of your agreement?
Yes, sir.
Now, by entering a plea of guilty, if this court accepts that plea, you will not have a trial of any kind, and you would be waiving rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose and the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you who appear at the trial, the right to question and cross-examine those witnesses, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have its silence used against you, and the right to testify at that trial if you chose to testify. Mr. Wise, do you understand those rights?
Yes, sir.
And again, do you understand that if you plead guilty and I accept that plea, you will be waiving those rights as they apply to this case?
Yes, sir.
Additionally, any appeal as it can pursuant to the pretrial agreement and the plea and sentence would be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to force or compel you to plead guilty?
No, sir.
Are you entering the plea of your own free choice?
Yes, sir.
Now, Mr. Champion has probably talked to you about the Michigan sentencing guidelines, probably tried to give you an estimate as to what he thinks those guidelines might be, and also give you an idea or estimate as to what he thinks the court would do at sentencing. Has anyone, including him, made any promise or suggestion to you as to exactly what the sentence would be?
No, sir.
I highlight for you that any statement made by anybody or even the scoring of the guidelines are not mandatory. It is the court alone that determines the sentence. Do you understand?
Yes, sir.
Knowing all that, do you still wish to enter the plea of guilty that we discussed earlier?
Yes, sir.
As to count one, larceny of building, how do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turning your attention to May 25th this year, 2025, up in Bloomfield Township here in Missaukee County. What happened, sir?
It was probably 4 or 5 in the morning, and I went into a lean-to and took a chainsaw out of there, and I was on my way to return it the next day, and I got pulled over on their road, and I was caught with saw.
And so this lean-to, what it was, tell me about it. What was it connected to?
It was connected to a pole barn.
All right. So, and did it have like a roof over it with doors or walls, or tell me?
It was just a roof, and it was open on the side of it.
Okay. And did you enter that without permission?
Yes, I did.
And did you know whose lean-to or a portion of this barn to whom it belonged?
I didn't know him personally. I just sold wood to him once before.
All right. And so did you have permission from the owner to enter that building to take that chainsaw?
No, I did not.
And then and then you left that building with that chainsaw without the permission of the owner. Is that correct?
Yes, sir.
Mr. Denon, do you believe you provided a factual basis?
Yes, Your Honor.
Mr. Champion?
I do also, Your Honor.
Mr. Denon, do you aware of any other promises or inducements?
No, Your Honor.
Mr. Champion?
I'm aware of none.
And Mr. Denon, do you believe the court's compliance with Mission Rule 6.302?
I do indeed.
Mr. Champion?
I believe the court has, Your Honor. Thank you.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for count one. Therefore, he is found guilty of that count. Count two and the habitual enhancement will be dismissed at the time of sentencing. Mr. Champion, is his address still the same that's in the file? You know?
That's his mailing address, but we can also get it. He's currently in treatment up north. He's in the transitional housing program.
Thank you. Mr. Weiss, someone's going to get you a packet of information. You're going to open it. You're going to complete it, follow the instructions, and then turn it back in.
Yes, sir.
You're going to have an interview with an agent from the Department of Corrections, and you have the right to have Mr. Champion present during that interview. Third,
yes, sir.
Mr. Harrison's going to bring to you a report called a pre-sentence investigation report, and he'll go over it with you prior to coming back to sentencing. This report must be prepared anytime someone's convicted of a felony in a court in the state of Michigan. This report will describe the offense, the pretrial agreement, statements or information you make or provide while preparing this report, as well as a report on prior criminal history, your performance on bond, your performance on probation. It will include a scoring of the guidelines, which again is not mandatory, and it will make a recommendation as to the sentence. Please keep in mind that it is merely a recommendation, as it is the court alone that determines the sentence. Do you understand, Mr. Weiss?
Yes, sir.
Do you have any questions, sir, about what we have done today?
No, sir.
Thank you very much. Bond hereby continues. If we need to extend the sentence to help coordinate with his treatment, of course, the court will do so.
Thank you.
Thank you. We are adjourned.
Thank you, sir.
Thank you.
You understand that Emmett is now on.
They went
Yes.
off now.
Okay, thank you.
Who was?
Trying to email back and forth with one of the agents to get Emmett jailed to come in.
Oh,
Right as they zoomed in, I heard Judge.
well,
In the case, so it's, yeah.
I'm going to ask Nicole to work on getting that done to get her on the docket sometime next week.
Is that the, give me a packet and I'll get it. Yep, thank you.
Yeah.
Mr. Weiss, you're good to go.
Okay, thank you.
Yes, sir.
Thank you.
Off everything. We're good.
Jack?
Yeah.
Very well, let's take up lead.
Oh, my audio was off. Sorry about that. Thank you, Keith. I appreciate your coming in on short notice. Sure, no problem. We've had a very densely populated day. And good afternoon, sir. Are you J. Paul Krantz?
Yes, Your Honor.
You're not Jim Krantz?
No, I'm Jay. Sorry about that.
All right, Mr. Krantz, you're charged in a misdemeanor complaint alleging false ID. The allegation, I don't say anything about it yet, but you got stopped on May 26th, and the allegation is you gave false, forged, or fictitious verbal or written information about your ID. That essentially you said you were your brother, and you weren't. The way it's charged, it's a misdemeanor punishable up to 90 days in jail and a fine of up to $100. You weren't driving, so there was no driving violation, but this is under the motor vehicle code because it's a driver's license. You pled not guilty to that charge, and you were set for a pretrial conference. You bonded out in June, and you posted a $400 bond. And then attorney Josh Robert was appointed to represent you. Excuse me, Luke Knopfinger. Josh Robert is the person who charged it. And we set a pretrial conference for July 11th, and you didn't show up. So I tried to call you without any success. And then I waited 48 hours before we issued a warrant for your arrest. And then you got arrested last night. The gentleman with us, I met with your lawyer, Mr. Knopfinger, this morning to see if we could somehow try to accomplish this morning, and he had other commitments in the circuit court. So Mr. Stickley is the chief public defender. So anyway, we didn't accomplish the pretrial, and then you didn't show up. So how did you get arrested?
Was at a friend's camper trailer. They was the police had showed up. They were looking for a guy named Trace or something like that, and I was just there, and they asked for my ID.
Where was that?
I gave them the correct ID, the correct information, and I was arrested.
All right. Well, you got arrested twice. You spent.
No, Your Honor. I got arrested on 5/26, and then I got arrested just now.
Yes. So yeah, you spent one day then and one day now, and I've got $400 of bond.
Your Honor, I spent 3 weeks in jail. That's why
3 weeks.
I spent from 5/26 until 6.
12.
I was in here for 3 weeks, 21 days.
Well,
I didn't bond out.
I guess I gave you a PR bond on June 12th when I saw you.
Yes.
All right, so I would represent the 26th to the 12th. That's 5 plus 12 is 17 plus 1. You've got 18 days of jail credit for this offense. If you were to just walk in off the street, I wouldn't give you 18 days jail for this. But I will represent that if you enter a plea of guilty to this charge, I'll give you credit for time served and the minimum allowable fine and time to pay it and let you out of jail. Otherwise, we could set up for further proceedings with your lawyer. As I mentioned, it's punishable by up to 90 days in jail and a fine of up to $100. What do you wish to do here today?
Plead guilty, Your Honor.
All right. Other than what I said to you, did anybody promise you anything to get you to plead to this?
No, they have not.
Or threatened you?
No, they have not.
Do you feel that I somehow threatened you to try to get you to plead guilty to this charge?
No, you have not.
All right. Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, sir.
Do you understand that if you had a trial, you'd have a right to have an attorney? All you got to do is ask me and I could appoint an attorney for you. If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf. You don't have to because you have a right not to testify. If you did not wish to testify, the judge or jury.
I have a job out there also, Your Honor.
Very good. All right. You'd have a right to have any of the witnesses for or against you subpoenaed to come to court. And you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor.
All right. On that day, May 26th, did a car get pulled over and you were a passenger in the back seat?
Yes, Your Honor.
Instead of giving them your real name, you gave them your brother Jim's name?
Yeah, Jim Kron.
Yeah. Why'd you do that? Because you were afraid you were going to get arrested for something else?
Your Honor, I was on parole at the time. I was scared. I was on parole. So I gave him a false name thinking I was gonna get out of it. Because I didn't have no other charges or nothing like that. I was on parole and I thought I was gonna get out of it. I'm off parole now. I'm discharged. I am done. Since that incident.
That's why you were in there so long, because there was a parole hold on you.
Right.
But you got 18 days jail. Are you still living on South Main Street?
No, I live, I'm a 59325 Steiner Drive.
What's that called?
Steiner Drive.
Oh, Steiner Drive.
Yes.
That's at Three Rivers?
Yes, sir.
All right, very good. Well, tell me about your job.
I work in Cavoni's. Italian restaurant in Three Rivers. I've been there for about.
I like their subs.
Yes, I've been there for about I've been here about 6 months, Your Honor.
All right, 18 days jail credit, 18 days. 0 fine. $75 and $50 state minimum fee. That's the minimum allowable fine. Why didn't you show up for your pretrial?
Well, I couldn't get a ride, and I was still scared about the whole parole thing. And
all right,
I got my life straightened. Besides this, right now, Your Honor, I got my life straightened out. I'm working. I'm doing what I'm supposed to be doing. Got good places to live at. Everything's been going good for me. I'm glad I'm getting this out the way.
All right, well, the warrant is recalled. You pled guilty. I gave you 18 days, credit 18 days. A lot of that is because of the parole hold, and I gave you the minimum allowable fine, which is $125. That's due by September 30th.
I'll have that paid.
All right, I couldn't see that you owed me anything else. All right, you're gonna get out of jail. Will somebody come pick you up?
I'm gonna have to, I can call somebody, but, if she can't pick me up, I mean, I'm only walking like 4 miles.
All right.
I'm walking
well,
back out there
yes.
River Road.
Yeah, it's not terribly far. All right, sir. You're gonna get out of jail. Next time, just tell them who you are and save yourself a lot of grief.
We're honor nothing.
All right, thank you, sir. Thank you for your help, Mr.
Okay, bye-bye.
Bye. Keith, I do appreciate you doing that on short notice. That helps free up some of my afternoon.
No, that's fine. Do we still?
And
we have
what's that?
Dogs?
Say that again.
Are you doing all of them, or is that just?
No, I just got this one.
Okay.
It was my bench warrant. Shayna thought I needed to do this.
Okay, I'll check it with Luke.
All right, thank you. Good afternoon, gentlemen. All right, I just finished that. So let me take that out so this guy can get out of jail. She's, yeah, I guess that's fine. All right, I'll be back and Miss Turner is here. You take this out so the guy can get booked out of jail, and then we're gonna start. I think everybody I need is here.
Oh, what did I make you do?
Miss Hampton, why don't you come have a seat right over here? Mr. McWaters, we got a seat over here. Turn the record on. Yeah, she said she thought the attorney would do it.
Good afternoon.
Good afternoon. You've got a really bright window behind you.
I know, hold on one sec.
Well, better than nothing. All right. This is file number 25326PP. It is a personal protection order the court issued in the matter of Emily Hampton versus A.B. Thomas McWaters Jr. Ms. Hampton is here and Mr. McWaters is here. This case has had a lot of attention paid to it. I issued the warrant or the PPO back in May. And as I stated on the PPO, I don't usually remove someone from the home with a personal protection order. There was an allegation of sexual assault and threats. As far as I can tell, no criminal charges have ever been made. The defendant denies those allegations, but and there was no lease. So I granted the order. The defendant asked to modify the order, and we had a considerable amount of discussion about trying to allow him to get the remainder of his property off the petitioner's property. And that didn't happen. So through respondent's counsel, Ashley Turner, they filed a motion in order to show cause why Emily Hampton should not be found in contempt for failing to allow the removal of the property. They're asking for attorney fees and any other sanctions the court feels are appropriate. Ashley Turner is here by Zoom. I did give her permission to appear by Zoom because every time she drives here, it's another billable period of time toward Mr. McWaters. So I did allow the Zoom appearance. The parties are here live. Ms. Turner, would you like to speak to your motion?
Thank you, Your Honor. Ashley Turner appearing on behalf of the defendant, respondent, Mr. McWaters. We did have some requests prior to filing this request for a show cause where we asked to modify the PPO or to terminate it based on our belief of Ms. Hampton's lack of reasonable fear of my client and the fact that he needed to retrieve his items. I recall very specifically during the testimony that Ms. Hampton was very clear that she wanted his items removed. She was willing and able to appear at those times that we all agreed on in court. And the exact opposite happened, right? So I think my motion was very clear, is that she explicitly refused access to third parties. Law enforcement had issues with how the order was written. It happened again the second time, issues with how the order was written. Law enforcement, would not enforce the order for his right to remove that property. I think this kind of almost goes back to our original motion to terminate the PPO. This is not the behavior of someone who's in fear of my client, the respondent. She shorted him in, a substantial amount of cash, purposely withheld some of his child's furniture, I think is still in the home. And she's refusing to comply with the order that she consented to under oath. So really, this is actually, to me, a clear example as to what the purpose of show causes are for. And I'd be really interested to hear as to why she shouldn't be held in contempt from her point of view. Thank you, Your Honor.
All right, first thing I'm going to do, Ms. Hampton and Mr. McWaters, will you both raise your right hand? You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Absolutely. Yes, Your Honor.
All right, they are requesting that you be found in contempt. There needs to be an established proof in civil contempt beyond a preponderance of the evidence, and in criminal contempt beyond a reasonable doubt. In criminal contempt, you may well be eligible to have counsel appointed to represent you. I don't, at this point, envision criminal contempt. I envision civil contempt. as the sanction if you are found to be in contempt. So I'm not going to appoint counsel, but you have a right to retain an attorney, which you've chosen not to do. I had hopes that this would be done with, and it wasn't. He contends that they were there ready to pick the property up and you wouldn't let them retrieve it. You were in here. We talked about it. I thought we had an arrangement. They were going to appear at a certain time and recover the property. And as Ms. Turner said you wanted this property off your property. There was a car and some other stuff. What happened?
So they did come to my house. The first time they came, there was no paperwork. I was not the one to call the officers. It was a third party who chose to call the officers. When they came, they said that there was no documentation.
Who's they?
The officers.
Yeah, but you were in here. You were sitting right there and we made this agreement.
Getting their property.
All right. So did you allow them to recover property?
Yes.
All of it?
As much as I could before they called the police on me.
Who called the police?
Amos.
He's present, Your Honor.
Yes. All right. So were you there?
Yes.
All right. And they came to recover the property and you were allowing them to recover the property?
Yes.
Then what happened?
They bombarded my door and went through with my son there.
What does that mean, bombarded the door?
My son opened the door and asked them to please wait until my mom got here because I left. It was 10:30 and I went to go to the gas station, come right back. And while I was gone, they came, pushed through the door and my son asked them, can you please wait until my mom comes home to come inside? There's plenty of things outside that they could obtain. Instead, they came in. They started moving things and my son called me crying.
Well, I had an established time that you were supposed to be there, so that wasn't a great
Correct.
time for you to leave in the middle of when they were supposed to
Correct,
get it.
I
but-
understand that. Due to the fact that it was 10:30, I wasn't sure, had no documentation of whether, because I left early, I have no idea of whether the dates were changed or what was going on. So I went to the gas station and back. And in the meantime, that had happened. When I got there, I closed the door because my son was very upset, crying hysterically. They got property off of they got his property off of my property. And then called the cops because I told them that they can't go inside right now. My son was obviously upset.
How old is he?
16. So they continued to get his property off of mine.
Or did they get all of the outside property off the
Yes, I
property?
have documents. I have pictures of all of it. When they called the cops, they said, there is no documentation, so you need to leave. Amos had called AB and.
Well, there was an order, but
Yes.
apparently they didn't bring it with them. That order wasn't like filed in the computer, so the police wouldn't have had access to it.
Right, so they asked them to leave. They asked me if I wanted them to unload the trailers, and I told them no. They
Did
stood
they
there
ask
for
you?
about.
No, stop. Who asked you if you want to unload?
Officers.
All right, so you said, no, go ahead and take the stuff you got.
Yes, and they actually stood around for about, I don't know, maybe a half hour or so, and then they said, we don't have time to be standing here waiting for you to move things, you guys just need to leave. I kept my mouth shut because I didn't have anything to say.
Those they were called and still are called civil standbys, where the cops would come and stand by while there was property being removed. They don't like them. They take a lot of their time and they're like, we got better things to do than sit here for 2 hours while you remove stuff, but
Exactly what
they
they
did
said.
some of it. So according to what I understood, nothing was removed. So you're saying everything that was outside was obtained.
I have pictures to prove it.
All right, why don't you hand them to the officer?
Your Honor, I
Just
just
a minute.
want, okay.
And you're saying some things from the inside were obtained, but then someone called the cops and that stopped.
Yes.
All right. With that, Ms. Turner, what's your contention?
So there were some items from the outside lawn that was able to be removed. However, everything inside the outer buildings had new locks on them, and she would not allow entry into those. And they also did not retrieve everything from inside the home.
All right. There are some ancillary buildings outside of the house, pole barns and other things. So did they get anything out of the pole barns?
Yes, they did. If you look at the barns are wide open.
Well, they appear to be. They're hauling off. I'll get to you in a minute, Mr. McWatters. They're hauling off a 4x4 car body, some sort of a check stand or something, some furniture, a couch, washer and dryer, or washer.
No.
Freezer maybe. There's 1, 2, 3, 4, 5 people in the picture. A car full of what looks appear to be clothing. The car keys to a GM. Something. Lots of clothing. A dog cage. More stuff packed into an automobile. Looks like medications. And here's a bunch of people kayaking on a river. Not sure what that's about. That may be in there by accident. Would you show those to Mr. McWatters? Now, what the show cause petition says. I'll start at paragraph 3. During the hearing on May 28th, petitioner Emily Hampton was placed under oath and testimony was taken. During that testimony, she testified that she wanted Mr. McWatters' items removed from her barns, home, and property. She continued to be available and willing to allow third parties to remove Mr. McWatters' items on Saturday, May 31st from 9 to 5. Paragraph 4, on May 31st, a group of individuals who were family members of Mr. McWatters came to Ms. Hampton's home. Upon entering the residence, the following items occurred. The parties associated with Mr. McWatters appeared at the home with vehicles, trailers, and towing equipment in order to remove all the items belonging to Mr. McWatters from the property. Ms. Hampton explicitly refused the third party's access to the property. Law enforcement was brought to the scene and law enforcement encouraged Ms. Hampton to allow the property to be removed, but she refused. Law enforcement refused to enforce Mr. McWatters' right to remove the property through the assistance of a third party. Well, that makes it sound like you got nothing out of there and you refused access to the property. Her sworn testimony with photographs is that you removed a bunch of stuff. She says you took everything from the outside, which makes paragraph 4 disingenuous. Paragraph 5, On June 7th, a group of individuals who were family members of Mr. McWaters came to Miss Hampton's home. Upon coming to the residence, the following events occurred. The parties associated with Mr. McWaters appeared at them with vehicles, trailers, towing equipment. Miss Hampton explicitly refused the third parties to enter the property. Law enforcement was brought to the scene, and law enforcement, same thing. Making it sound like you got nothing. So were the pictures that you're showing, are they from May 31st?
There's a few from both.
All right, so they came on May 31st and again on June 7th. What happened on June 7th?
June 7th, I was gardening in my front yard. They came, they wanted to get the rest of the property. I said, that's fine. Like I said, I didn't say anything to anyone. I didn't want to cause any confrontation. Again, the police were called by Amos. And when the officer arrived, she asked me what was going on. I gave her the documentations. She went and talked to the third party. In the documentation, it did say A.B. McWaters, not A.B. McWaters Jr. A.B. McWaters told the cops that his name's Tom. So
He goes by Tom.
Mhm. So she asked them to leave the property because the documentation wasn't correct. She asked me if I wanted them to unload their vehicles again, and I told them no. I was accused of locking all of my barns, which I did not do. There's one lock on one of my barns, and that exact barn has a garage door, a sliding garage door he took the foam, well, him and I both took the foam down around it to be able to open it. It is not on the track, so you have to like pull it out and slide it open. It's very difficult to get open. So that's where they're coming at me with, I'm not giving them anything else to shut, or the red barn. That's inaccurate, but if you can't get it open, to me, I'm not saying anything. You should have spoken to TJ to where he could explain to you how to open it, because I can barely open it.
All right, well, the person that actually, Brandy M. Monson for the plaintiff, if your testimony is truthful, these petitions aren't accurate. Mr. McWaters, you weren't there. So who was there? Your father?
My father.
Who goes by Tom. And Amos Klein is your cousin?
No.
Just a friend?
I've divided these pictures out too a little bit.
All right.
This first file here were things that she contacted my ex-wife in the beginning of the PPO issuance to have my belongings removed. That's the Suburban with all the clothes in it and stuff. That was not received on either of those days.
All right, so that Suburban with the clothes in it was not recovered on May 31st?
No.
Where is that?
I have that. My ex-wife brought it to me.
All right, so that's recovered, but not on that day.
Correct. That was way prior to all this.
All right.
I believe it was May
And
13th.
then there's 4 photos here too of a car with the hood open.
Mhm.
If you look in those photos, you'll see my whole wall of tools that I'm trying to get out, and that is in the red barn. You can tell by the metal in this picture that it's the corrugated metal that's seen in this photo.
Well, why weren't they able to get that stuff out?
I was told the door was chained shut with a new lock installed.
Just a minute.
All right.
All right, so did they haul off your 4x4 and that car body and the other stuff?
A 4x4 was removed, a car body was removed, a stand-up freezer, and a engine dolly and the couch. That is it, Your Honor. 1, 2, 3, 4, 5 things.
What is still there?
Every one of my tools.
every tool in this picture right here that she supplied us with is still there, to the best of my knowledge.
All right, what
my
building are they in?
The red barn.
And it has a entry door, a human
It
door?
has a man door and a drive-through drive-through door.
All right, and which door was locked with a chain?
I believe I wasn't there.
All right, well,
This is just what I was told as to why they couldn't get in.
all right. Mr. Klein, would you come up to the podium, please? Well, in fact, let's come right here in the witness box. Raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, sir.
Have a seat if you would and state your name.
I'm Amos Klein. I'm TJ's friend.
And were you one of the people that went to this property on Lang Road on May 31st to recover property?
I am.
Did you also go back on June 7th?
Yes.
On May 31st, did you call the police?
I did not. TJ's aunt actually called the cops.
All right, who was that?
Debbie.
Rebecca Seacard.
There we go. I'm thinking of Debbie's aunt. Sorry.
All right, I see Amy's dad and some others in the picture. What were you able to recover on May 31st?
Vehicles on the outside, the freezer, the lawnmower. I think we grabbed a couple of the kayaks that were outside. Some of them weren't there that he owns.
Did you recover any property from inside the house?
Half of a couch.
All right, what happened? Were you prevented from, her testimony was her son was there, he was quite upset. He wanted her to come back.
We knocked on the door and he came. I told him the situation about how there was a court order to recover TJ's property and stuff like that. And he was like, all right. I was like, can we come in and confirm a few things? Let me call my mom. He let me and his daughter come in to confirm that her dresser was there, the couch was there, and a few other things. He got his mom on the phone and she asked me to leave the house. So I went back outside. She hung up on me and called him right back. Yelling, screaming, grounded him. This is why he was pretty upset and crying. And at that point, Mr. McWaters asked him, well, now that you're in trouble, can we come in and start collecting this thing?
By Mr. McWaters, you're talking about Tom?
Yeah. And he said, yeah, sure. He went up to his room. At that point, we went in, grabbed his daughter's dresser and half the couch, and Emily showed up and shut the door behind us. That's all we were able to recover out of the inside on the 31st.
All right, what about the stuff in the red barn?
We've never been able to get any of the doors open. I personally haven't been the guy to check the garage or barn. He's not here, Brandon's not here. Yeah, we haven't recovered anything really inside.
All right, you don't even know what's in there.
I do know what's in there. I've known TJ for 20
Okay, so you've seen what's in the barn.
Yeah, I've used the tools with him on the cars in the barn, so. I helped him move half that stuff in there.
Did you try to open the sliding door?
It didn't budge. With officers present, I'm not trying to force my way inside anybody's property while they're
And,
telling us
and
no.
was it locked with a chain?
From the inside, I think so. It was tied with a wire or a chain or something. The entry door, the man door, was padlocked. We don't have keys for it. We can't just cut locks off without permission.
All right, what happened then? So at some point you took the property you had left.
Yeah. The cops wanted us to leave. She didn't want us there. We didn't want anybody getting arrested for just, trying to grab somebody's stuff, so we left.
All right, tell me about what happened when you put back on June 7th.
I really don't even remember what we recovered. I don't think we got anything. She didn't let us inside. I think we grabbed. I don't really remember what we grabbed. I don't feel like we got anything outside. What were the pictures of?
All right, well, I'll get to that in a minute. All right, so, the petition makes it sound like they didn't get anything. She makes it sound like they got everything. So the truth is usually somewhere in the middle. And I'm disappointed that we didn't accomplish this, so these two people wouldn't have to deal with each other. All right. Were you able to get into the Red Barn on the 7th?
No, same thing. No key to the lock, no, we're enforcing entry. We're off to assets to leave. Take what we were able to get, which is probably only a few things. Dude, crap, I feel we got something that day. What is that?
Ms. Turner, do you have any questions for Mr. Klein?
No, not at this time, Your Honor.
All right, Mr. Klein, you can step down. Tom A.B. McWater Sr., would you come forward, please? You please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, sir.
All right, have a seat and state your name for the record, please.
A.B. Thomas McWater Sr.
Do you go by Tom?
Yes, sir.
Were you present at this property on Lang Road on May 31st?
Yes, sir, I was.
We heard the testimony of Amos Klein about the things that were recovered. You have to speak your answer.
Yes.
All right, so you heard what he said. Do you agree with what you recovered that day?
Yes, we didn't get the car that day. We got that on June 7th or whatever. But
Well, what happened on the 31st that prohibited you from recovering the remainder of the property?
well, when we got there, she wasn't there. The son answered the door. Amos talked to him. He let us in. I walked in, I guess what was TJ's room. I ended up walking back out, and then, so I don't know what they got out of the house. Then he called her son, he called Emily, and she told me she was upset. So we were all supposed to leave out of there, and then he was upset because he was getting grounded for letting us do what we were there to do. So then I asked him if it was all right to enter the house since he was already grounded, and he said sure and took off. And I turned around and went outside towards the barns, and Amos and everybody else that was there to help in the house went in. And I seen parts of the couches and the dresser and the freezer.
All right, did you know that your son had a large number of tools inside that red barn?
I know he told me yes.
Did you ever been in it?
No, sir.
Did you try to get in it?
Yes, sir. It was shut with a cable, wire cable, and a lock, and the entry door was locked. It needed a key, I guess.
When you
And
say
I have bolt cutters, but that was probably not wise to use them.
That was probably wise. You get smarter when you get older.
Yes, sir.
So you're saying that the sliding door was locked with a cable and a lock?
Yes, the cable was on the inside and the lock was on the outside.
Did you ever ask Miss Hampton to unlock the door?
Oh, she wasn't going to.
Yeah, all right. She wanted you to leave. All right. Now, what about going back on June 7th?
On June 7th, we showed up. That's when we got the car frame. I think maybe his lawnmower that was apparently missing a couple parts. We wasn't able to get a lot before.
So
There was a
what stopped it
discrepancy
on,
with the senior, junior.
oh, whether you were,
Yeah, because I, same name, just it didn't say senior. or junior.
so who was the discrepancy with? The police?
Just Hampton and place.
Oh, she wouldn't do it because,
Yes, no, she was the one probably pointed it all out.
well, it was supposed to be third-party agents, and that's what you guys were. Anyway, you weren't able to get in the Red Barn on that day.
No, sir.
Ms. Turner, do you have any questions for Mr. McWater Senior?
I do, if you don't mind, Your Honor.
No, go ahead.
Mr. McWater Senior, were there any other areas that you needed to access besides the Red Barn and inside the house?
As far as I know, everything else was gotten, that was outside, just not in the Red Barn and whatever he had in the house.
Thank you. In regards to June 7th, when you arrived, was Ms. Hampton present?
Yes,
Okay. Did she ever come out and speak to any of you?
she came out and spoke to someone, yes, wasn't me.
Were you asked to leave at that point?
After the police had showed up, then we were asked to. We was able to finish loading up the car frame, the Pontiac, and the lawnmower. Whatever was loaded, that's what we got. Again, no access to the house or to the Red Barn.
All right, thank you, Mr. McWaters. No further questions, Your Honor.
Ms. Hampton, do you have any questions for Mr. McWaters?
Well, I'm wondering why you're telling me or stating that I was the one that wouldn't allow you guys in. I didn't speak to anyone. Nobody. I sat there and gardened the entire time. And every piece of the property that was in my home that belonged to him was on the front porch.
Again, I didn't go in the house.
All right.
Well, Angus and Brandon are the ones that moved the couch off the front porch. The freezer, the dryer, they moved that as well. They didn't move the lawnmower on that day. They moved it on the first time.
Well, and again, this is stuff you wanted off the property. Mr. McWaters, you can go have a seat. All right, so.
Your Honor?
Yes?
I was going to ask if I was going to get an opportunity to ask questions of the petitioner.
All right, I'm sorry. Please resume your seat. She's got more questions for you.
No, the petitioner, Ms. Hampton.
Yeah, I'm gonna ask her some questions too, but
Okay.
why don't you go ahead and you ask?
Okay. Ms. Hampton, in regards to June 7th, you said you were out in the garden at the time when individuals arrived?
Yes,
Did you speak to anybody when they arrived?
I did not speak to anyone when they arrived.
Did you speak to anyone later on?
As they were leaving, after the police got there and they were loading up the couch, because I still allowed them to take the belongings after the police got there and told them to leave. I said, Brandon and Kyle, which is the third party that I know, they asked me how I was doing, said the best I can, just small talk, and that was it. Those are the only people I spoke to.
Did you ever interact with the police officers that day?
Yes,
Okay. What did you discuss with the police officers?
I showed them the restraining order and the documentation.
When you say documentation, are you